Infrastructure. Item number 24.
Your name?
PJ Dutta.
Mr. P.J. Doctor, the learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous. Accordingly, he has instructions to withdraw the matter. In that view of the matter, petition stands closed.
Oblige.
Your Lordship, I beg to mention item 23, Lordship, with the consent from other side. I beg for the adjournment, Lordship, because my senior is out of station.
You will be lucky the matter would not be taken up, maybe, because I've got a lot of other matters today. If it is not taken up, it is good. If it is taken up, I will take it up. No adjournment 2015 matter.
Lordship, but my senior is out of station.
You do it. I will help you out. If you have a case, you make a little bit of case, I will try to help you out. Yes.
Item number 1.
Yes.
Made. The petitioner's husband died on 28 2018 due to the institution. After the death, she has filed representation before the respondent authorities paying for compensation, but that has not been materialized till date. That is the concise case of the petition. Now, identical issue has already decided by this honorable court in series of decision. Now we are having one of the order passed by this honorable court on the issue since the government has framed the scheme, whereby it is provided the amount of rupees 4 lakhs is to be given to the deceased family. That is the order. And so far the contravention is concerned, my lord, in the affidavit filed by the respondent number 6, my lord, they have admitted, my lord, there is a contravention on the part of the FEDCL authority.
Yes, Mr. Bonik.
It's unfortunate someone has died, but so far as the inquiry report is there, we all have to go by that, whatever is there.
Where is the inquiry report?
That's in the affidavit filed by the 6th respondent. May I?
Yes, page 63.
Possibly, but this is not marked in that manner, so I'll just carry
Page
on.
29.
Internal page 3 it would be, perhaps.
Page 29. 29 of the affidavit filed by
The respondent number 6 has filed a 4-page
affidavit.
affidavit.
This is in there in the affidavit in reply filed by the petitioner
Very good. I'll
against
just-
the affidavit in opposition filed by respondent number 4 to
very
7.
good. It would be the same thing.
There
the
at
same
page
thing.
number
29.
29,
29.
it has been mentioned that
Clause
how
10.
the accident happened.
Clause 10, if
All
I may.
leading to the death is from the above stated facts and several leading to the accident. It appears the victim received the fatal area, unauthorizedly tried to lift and displace the snow during the accident.
What had happened, Mira?
Yes.
There was a storm the other night, the previous night, and this thing, it was lying there. Next morning, since the jute was there, there's a very natural events occurring. To remove that, and thing happened. And so far, the contribution party is there. But to be fair enough, unless there's a challenge by APDCL in appeal to this thing, it will be binding. Lordship may not put it in my words, but that will be correct way. Have there been appeal on challenge on that? Then a different question altogether.
Now, in view of this report, he's entitled to the minimum of the amount of 4 lakhs.
He would be entitled.
If
Even
he,
otherwise
if he
also.
wants to show further negligence, it is a different aspect to the matter for which,
Negligence is not there. Negligence would not be
no,
attributable.
no, any other negligence, if it
negligence.
is there,
Lordship.
then if he can show, then he can very well go to the civil courts
Lordship,
for that.
lordship,
But
lordship.
otherwise, he will be bound to, if only on the basis of this accidental report,
Lordship.
only bound to 4 lakhs.
And
You are
also,
on that.
Lordship.
Heard Mr. M.U. Mondal, the learned counsel appearing on
My lord,
behalf
may
of the
please to
petitioner.
observe, sorry for the interruption, madam. Lordship, may you please to observe. In the meantime, I'm not on the instruction. If any appeal has been filed, subject to that, as on date,
Have you filed the affidavit?
we have filed an affidavit.
Have you stated that you have filed appeal?
No.
Then
It was not.
why should I say that?
Lordship.
Paragraph, page number 4, you say, the PDCL reported the matter to the officer and said the PDCL informed the chief elector.
That was sometime
Yeah,
in
so and so,
2020.
Iman and Iman have been informed that the appropriate forum would be the civil court, nothing else.
Lordship.
Then you know that there is a report. When did you file your affidavit? On 24th of February 2021.
21,
And the report had come on
2nd February.
19/11/2021.
No, it was filed by way of affidavit.
You will be knowing it.
Yes.
Are you not aware that when a
The-
report
the-
is given,
The requirement under this thing is that the interchanging, the exchanges are not done.
you send the report, you ask.
No, we do
for
not
it.
send the report. The report is by the government.
No, the report is by the government, but the fact that you have sent the papers to the chief electoral officer,
That's a view.
you are supposed to also know it. You cannot say that they have not informed me.
Lordship.
Heard Mr. S. Bonik, the learned counsel appearing on behalf of the petitioner. Mr. S. Bonik appears, M.U.
Four,
Mondal appears for the petitioner. Mr. S. Bonik appears for the respondent numbers 4, 5, 6, and 7, 7, 8.
5 is Dhubri, Deputy Commissioner Dhubri.
Huh? 4, 6, 7, and 8.
No, not 6, 4, 7, and 8. 6 would be
4,
government.
7, and 8. Yes, Mr. N. Goswami appears for,
5 and 6.
who appears for power?
I put it 1, 2, 3, 4, 1, 2, 3, 5, 6, 6.
And so appears for him. The instant writ petition. Has been listed before this court at the stage of admission. Taking into account that the pleadings are duly complete, the instant writ petition is taken up for disposal at this stage. The facts involved herein is that the younger brother of the petitioner, one Sophia Rahman, since deceased, died on 28 2018 due to electrocution for the alleged negligence of the electricity department. Accordingly, on 21/8/2018, a complaint was lodged by the petitioner by complaint was lodged by the brother of the deceased on 21/8/2018. It further transpires that a Chapot police station case number, it further transpires that a GD entry number 470/2018 was registered in Chapar police station. And the postmortem was conducted on 28, 2018 in the civil hospital Dhubri, wherein the cause of death was shown as due to shock as a result of electrocution sustained by the deceased. Subsequent thereto, the petitioner herein, who is the wife of the deceased, submitted a representation on 28/9/2018 before the chairman APDCL, praying for compensation of rupees 15 lakhs for rehabilitation of the deceased family, but no such compensation was paid. Itu que é mais curioso, sabe? Being aggrieved by the action of the respondent, APDCL, in not granting the compensation, the petitioner has approached this court seeking a direction upon the respondent authorities to pay the compensation of rupees 15 lakhs and in the interim to pay an amount of rupees 5 lakhs. The instant writ petition was filed on 3/12/2019. This court, by an order dated 3/1/2020, issued notice making it returnable on 10/2/2020. It appears on record that the respondent number 4 and 7, that is the APDCL and its official, had filed an affidavit in opposition. In paragraph number 5 of the said affidavit in opposition, at this stage, it is relevant to take note of that the said affidavit was filed on 24th of February 2021. In paragraph number 5 of the said affidavit, it was mentioned that, as could be learned from the local public, due to high wind, thunderstorm, and heavy rain on the previous night of 28/2018, one low tension LT conductor of Tarangapur Part 1 snapped. In the morning of 28/2018, the victim tried to lift the snap conductor himself for keeping in a different place. This resulted in the electrical accident. It was further mentioned that the snapping of the low tension line due to high wind, thunderstorm, and rain was an act of God, and APDCL had no control over it, nor any amount of vigil could have prevented it, for which the APDCL is no way responsible for the snapping of the subject low tension line and the consequent electrical accident. It was further alleged that the victim himself was responsible for his fate as he tried to remove the snap line by himself without informing the APDCL authorities. Further to that, it was mentioned that the APDCL reported the matter to the officer in charge, Chapor Police Station, Chapor, Wide, SDE/CESD/T-35/2017-18/367 dated 28/2018. Further to, in addition to that, the APDCL also informed the Chief Electrical Inspector, cum advisor, Government of Assam, about the accident via a communication dated 28/2018. It was therefore the specific stand of the APDCL that as the questions involved therein in the writ petition were disputed, questions of facts, and as such, it is the civil court who would be the appropriate forum for redressal of the grievances rather than proceedings under Article 2 to 6 of the Constitution. It further appears that on 27/10/2021, an affidavit in reply was filed by the petitioner against the affidavit in opposition filed by the respondent number 4 and 7. To the said affidavit in opposition reply, the Assam Electricity Regulatory Commission notification dated 8th of March 2019 was enclosed. The Schedule B to the said regulation categorically mentions that the compensation payable for loss of human life as a result of electrical accident was rupees 4 lakh per person. Clause 1 of Schedule B. Further to that, to the affidavit in reply, the report of the electrical accident inquiry report given by the Deputy Chief Electrical Inspector, Government of Assam, was enclosed as Annexure B. It is pertinent to mention that the said report is dated 19/11/2021 and affidavit so filed by the respondent numbers 4 and 7 was dated 24th of February 2022. Oh, no, 21. সেইটো নালাগে। In the said electrical accident inquiry report, it reveals that the victim received the fatal electrical shock while the victim unauthorizedly tried to lift and displace the snapped conductor lying on the roadside with the help of a bamboo for clearing their place of jute washing. It was further mentioned that there are more than one conductor joints in a span of overhead electric line involved in the accident in issue. And the said electrical line was drawn without any protective device right from the substation point to the utilization point. Further to that, it was observed that the low voltage distribution line emanating from the pole mounted distribution substation of the aforesaid village are without statutory electrical protective and isolating device and are not being maintained in an appropriate manner to ensure safety of personnel and property. Further to that, it also appeared to the Deputy Chief Electrical Inspector, as noted in his report, that the overall condition of the electric supply installations, including overhead lines in that area, were unsafe, and there is every possibility of occurrence of similar type of electrical accident in any time unless total and suitable corrective measures are not initiated immediately for public safety. Further to that, in the report, the various contraventions which had led to the accident were also mentioned. Oh. The said report was dated 19th of January 2021, and the affidavit in reply, opposition filed by the petitioner, by the respondent number 4 and 7, was on 24th of February 2021. There was no mention whatsoever in the affidavit so filed by the respondent number 4 and 7 that there was any proposal for the purpose of filing an appeal against the report so submitted by the Deputy Chief Electrical Inspector. Be that as it may, as on today also, it is, be that as it may, the fact that the petitioner, the husband of the petitioner had expired due to an electrical accident which had taken place as is evidenced by the electrical accident inquiry report. This court is of the opinion that the petitioner herein would be entitled to, would be at least entitled to the compensation in terms with Schedule B of the AERC bracket compensation to victims of electrical accidents bracket close regulation 2019. Yes, you wanted to say something.
I leave it to your lordship, but at the time of the accident, this regulation was not in force. The earlier regulation, the whatever was there, is at page 25 of the petition, on the basis of which claim is there. This came subsequently. The cause of action which arose would be prior, as per page 25. I leave it to your lordship. It's my duty to point it out. There at page 25, that's also the claim. But to bring in the subsequent notification perhaps may not be applicable in every case.
Last time too. Well, would be entitled to compensation. Mr. S. Punik, the learned counsel for the respondent number 4 and 7 submitted that at that relevant point of time, the regulation,
Office memorandum,
the office memorandum dated
18/12/13,
18/12/2013
page 25.
was holding the field. And AERC bracket compensation to victims of electrical accident regulation 2019 came into effect only subsequent to the incident which had taken place.
This is more like no fault liability. my lord.
And as such, the compensation, if so, has to be in terms with the office memorandum dated 18/12/2013. Upon perusal of the documents on record and taking into account that in spite of the fact that the husband of the petitioner had expired, there was no attempt on the part of the APTCL to pay the compensation in terms with the office memorandum dated 18/12/2013. And the electrical accident inquiry report was awaited for the purpose of this granting, was awaited by the respondent APDCL, which was rendered only in the year 2021. This court is of the opinion that the petitioner herein would be entitled to the compensation in terms with the AERC bracket compensation to victims of electrical, would be at least entitled to the compensation in terms with the AERC compensation to victims of electrical accidents bracket regulation 2019, wherein it has been categorically mentioned in clause 1 of schedule B that the compensation payable on account of death, on account of loss of human life as a result of electrical accident would be rupees 4 lakh. Accordingly, this court therefore disposes of this incident with petition, thereby directing the respondent APDCL to pay the amount of rupees 4 lakhs to the petitioner within a period of 10 days, 15, 20.
Should be actually forthwith on the application, fairly, without recording my submission. It should be that way.
There the problem arises
Sir, I
without
can-
recording the
I cannot
submission.
make a summary, as an officer of the court, I can say that.
Within 30 days from the date of submission of a certified copy of the instant order. The above the petition stands.
This would hold good in all, for all cases, actually. This observation is correct also. If you did not move then this follows.
And number 2.
Yes, Mr. Bora.
May I please, your lordship? My lord, the petitioner is serving in the Sashastra Simabal, my lord. There was some Sashastra Simabal, my lord.
What is that?
SSB, my lord. Sashastra
Yes.
Simabal. So there was some family dispute with the wife, my lord, and thereafter the wife approached the respondent authorities, and the impugn order at page 27 has been passed, my lord, at annexure 3, page 27, my lord, whereby an amount of 10,000 was deducted per month from the salary of the petitioner for payment to the wife, my lord.
As per so and so of the rule, the commandants are having statutory power under being the competent authority had accorded approval to deduct an amount of rupees 10,000 of this union, being family maintenance allowance to his family name from the payment of till the outcome of the court case. What court case is this? Yes, madam.
No, there are several courts, case filed there, my lord, in Kerala, my lord, regarding family dispute, divorce case and another domestic violence case. So regarding that. So after this order, my lord, the petitioner filed a representation, and thereafter, my lord, at page 32, your lordship will find a convening order, my lord.
What is this convening order?
My lord, Sri Shankar Prasad.
Conduct a one-man inquiry, court inquiry to inquire all the facts for reconsidering appropriate maintenance to the remand. The convening order is Then what happened?
Important point is keeping in mind of her requirement while a lady is living in a city. So that is the point. And thereafter, my lord, this court by order dated 12/11/2021 has been quick to observe that interim protection will be considered after filing of the affidavit by the.
No, no, no,
respondent.
no. This order 17/6/2021, what does it say? Why are you aggrieved?
No, no, my lord. I was aggrieved against the order of 22/5/2021. At an
You are not aggrieved with 17/6.
17/6, that was based on my representation. But thereafter, when nothing was happened, then I approached this honorable court, and thereafter, my lord, the respondents has filed an.
No, what happened in 17/6?
After that, my lord, a detailed order has been passed, which has been reflected in the affidavit filed by the respondent, my lord. Affidavit filed by respondents, my lord.
Where?
Page 5, my lord.
Page 5.
Page 5, paragraph Roman 6.
Yes.
So last
Representation
portion.
to reconsider the order and deduct 5,000 instead from his monthly payment for the demand of remand. On receipt of the one man committee was ordered to inquire as to all the facts to reconsider appropriate maintenance amounting on remand. Accordingly, the court of inquiry assembled on onward and going to the extent of the opinion of family maintenance per month.
Then, my lord, what happened, my lord, in the convening order, because this has been reconsidered, keeping in mind that her requirement while a lady is living in a city, my lord. So during last, when the.
What is your salary?
Salary is around 40,000, my lord.
Oh.
And in paragraph 10, my lord, I have stated in details what are the deductions from my salary, my lord. And one important thing, my lord, on last occasion, because her pair has been considered, considering that she is living in a city. So on last occasion, the honorable court was directed to, please to direct the respondent to obtain a report from the concerned deputy commissioner whether the lady is living in a city or a village. So that report has come, my lord, my lord, because that 10,000 has been considered paid, my lord, considering that she is living in a city, my lord. So whether the lady is living in a city or not, that report was called for by this honorable court, and that report has.
Your salary is how much?
My lord, around 40,000 something, my lord.
40,000, and you are paying 39,000.
No, my lord. Now.
Yes, at page 10.
Yes, my lord.
Then-
Then I am stating, my lord, apart from that, my lord, because now he is posted in Assam, additional 10,000 he is getting as a, that is called high risk. High risk amount and something other 10,000 additional he is getting now, my lord.
So good. You pay that 10,000.
No, my lord, because the respondent authorities, while considering, they have considered that she is living in a city. So that report has been called for. Your lordship may peruse once that report, my lord.
What report?
Whether that lady is living in a city or village, my lord.
You know.
I know, I have said, my lord, but
Where does it say?
village, my lord.
But that is an order on 18/9. Therein only they have taken into account. You have not challenged that order.
No, my lord, that order, because
Why should this court look into those?
no, that order has been never communicated to me, my lord. That order has not been communicated to me, my lord.
Mr. Bora, this is not a case where any question of interference under 226 appears.
My
Why
lord,
should this court interfere under 226?
I-
10,000,
I am.
you have got 40,000. I tell you, how are you running your household? How are you eating? Tell me. If you are spending out of 40,000 on LIC premium 865, LIC premium 2865, SBI life insurance 1,000, SBI Mutual Fund 2,000, SBI Personal Loan 15,500, Bajaj Finance EMI 8,000, so and so. House rent for parent is 4,000, mother's treatment is 5,000, total is 39,605. How are you living at 395?
Yeah, no, my lord. Because additional 10,000 now he is getting, my lord, because he is posted here, my lord.
So
50,000 he is getting.
then
my
why
lord.
are you spending all this thing unnecessarily? You have a personal loan of EMI for 15,500 for what?
For construction of a house, and she is staying there in that house, my lord. Construction of a house, my lord. She is staying in that house.
Where?
In the
Where does she stay?
in a village, in petitioner's house, my lord. And
Where?
she has ousted her parents, his parents also from that house, my lord.
No, where?
It is in, my lord.
Who is appearing for response number 7?
No, my lord, notice has not been issued yet, my lord. Notice has not been issued, so by the order dated 12/11/2021, this honorable court has been pleased to observe that, my lord, after filing of the affidavit, my lord, interim prayer will be considered, my lord.
This court is not going to consider. Are you paying this 10,000 or not?
Yes, my lord, that I am.
Oh, it is deducted.
Yes, my lord. That
Very
is,
nice. Now, how are you surviving?
my lord, that's why I am before your lordship.
What loans have you taken because of the 10,000 been taken? Tell me.
Because one of his brother is working in Gulf country, he is taking some financial assistance from him now, my lord.
Why? Why is the brother not who is working in the Gulf country not looking after the mother and parents?
He is also paying, my lord. But he is there, but the petitioner is here, so he has to look after. He is sending money, my lord. But I am before your lordship as a matter of equity, my lord, because a lady, she is living in the house of the petitioner. So to earn her daily livelihood, my lord, 10,000 rupees is not required, my lord. If she was staying in a city, that is a different, because the authority considered, because thinking on the basis that she is staying in a city, my lord. And that's why on last occasion, your lordship has been pleased to direct the respondents to produce a document from the concerned deputy commissioner, whether the lady is residing in a city or a village. I am agreeable to pay some amount, but 10,000 is little more for the petitioner, my lord. That is because in a village area, my lord, no, there is no children.
Where is she staying?
My lord, at page 3, my lord, it is received village, Nelly Villa, Puther,
Where?
Thiruvananthapuram district, my lord, Kerala.
Oh, you know how expensive it is in Kerala.
No, my, she
It's
is,
cheap.
she is staying at the residence of the petitioner. There are so only for her livelihood, my lord, 5,000 or 7,000 is enough, my lord. Because she is staying in the house of the petitioner, my lord. Not.
Okay, we issue notice. I'm not going to stay in it.
My lord, some consideration, interim protection. Some.
Sorry, how can this court do so without hearing the respondent? You are making a statement that she is staying at your house.
From records, my lord, I can show that her payer has been considering on the basis that she is staying
And
in a city.
plus you pay another 2,000 from your pocket for her to appear here. Na? How will she appear? Tell me, you are going to pay the additional expenditure for her?
No,
No, who is going to engage? You are paying her 10,000. Is she working?
no, my lord.
Then you have filed the instant writ petition here, where she is residing there.
Because the cause of action arises
Maybe,
here,
but how will she engage a lawyer? Tell me.
because my lord, there I cannot file the writ petition because the cause of action has arisen here, my lord. The impugn order has been passed by the.
So you pay another additional 2,000 whenever the other side lawyer appears. Okay?
No, that observation may not be recorded.
No, that has to be given. Because then only, how is it? You are paying her 10,000.
Yes,
She has to survive. And another, how will she engage a lawyer of anybody?
She has
In
filed.
Guwahati, do you get a lawyer less than 2,000 per day? No. We'll have it on every date. So you have to pay every day 2,000 for him.
No, we do not.
No. Then you do it because this is the type of unnecessary litigations you have filed. Heard Mr. D.P. Bora, the learned counsel appearing on behalf of the petitioner. Mr. Ms. A. Gayan appears on behalf of the respondent numbers
1 to
1 to 6.
1 to 6, my lord.
1 to 6, my lord.
1 to 6. Good stuff. Although it appears on record that affidavit has also been filed by the respondent numbers 1 to 6. But no notice has yet been issued to the respondent number 7, whose presence is very relevant for the purpose of adjudication of the instant dispute. Accordingly, issue notice making it returnable on 24th of July 2023. Steps be taken. As the respondent number 1 to 6 are duly represented, you need extra copies.
no, my lord. We have already filed affidavit.
As the respondent number 1 to 6 are duly represented, and Ms. A. Gayan, the learned counsel, duly submits that she requires no extra copies, the petitioner is exempted from serving extra copies, exempted from the requirement of serving extra copies upon the Ms. A. Gayan. In respect to the respondent number 7, steps be taken by way of registered post as well as usual. You want an early disposal? Dusty service?
No, my lord. Justice service is not possible.
Okay.
My lord, in addition, that may be permitted if I can.
The petitioner is further given the liberty to take steps by way of dusty upon the respondent number 7 and file an affidavit of service on or next date.
Deeply obliged.
And number 3.
As per instruction of my clan, Your Lordship, I want to withdraw the matter.
Your name?
SI Akan, Your Lordship.
S.I. Akan, the learned counsel, appears on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers 1 to 5.
All.
The learned counsel appearing on behalf of the petitioner submits that why you want to withdraw. So, infructuous
Yes, Your Lordship. Infraction.
Yes.
submits that the instant writ petition has become infructuous and accordingly he may be permitted to withdraw the instant writ petition. According in that view of the matter, the instant writ petition stands closed.
Deeply obliged.
4.
Non-payment of medical reimbursement bill.
Hmm.
Now, the husband of the petitioner, he was an employee of PWD, senior assistant, he retired. He retired from Romia division.
Hmm.
And his son was working at Nalbari division. He is also a senior division assistant. His son applied for his father's reimbursement initially. It was approved by the medical referent board. Thereafter, it is approved by the district admissibility board. And thereafter, it was forwarded to the undersecretary for payment. Then undersecretary returned it, directing the petitioner to submit by himself, as because he is also retired employee. Thereafter, father applied, that was also approved, but till then not paid.
My lord, the matter on the earlier occasion it came up. This court has passed an order, my lord, on 17/12/21, my lord.
11.
17/11, my lord. 11, my lord. My lord, because of maybe some technical reason, my lord, we got the order. There was supposed to be this copy was supposed to be supplied to us, my lord. We were supposed to communicate. On 18th, my lord, it was of this month. It was on 18th, 18/5. We got the copy, my lord. Thereafter, we have communicated, my lord. This morning, I have spoken, my lord, to the authorities. They are processing it, my lord. They said for the payment.
So the fact that you are going to pay this 1,36,000, that's the amount?
My lord, yes.
1,36,708.
Yes.
There is no denial to that amount?
My lord, as for the
I'm not on that.
last
Mr.
order, my
Mr.
lord.
Dhar, let us, The amount which have been approved by the medical board
My lord, page
of
45. my
an
lord.
amount of rupees 1,36,708.
My lord.
Are you willing to pay? Are you going to pay?
My lord, I have a WhatsApp of this communication, my lord. That is what the PWD told me, that processing the document for payment. That is what I received.
So it will be, so you are processing it.
I am processing, my
So
lord.
I'll dispose it of directing you to make the payment. As you are processing the, or we'll take it up at 2, just ask them, are they processing this amount of 1,36,000? Just ask them to the,
I will try to. get
because these matters, you see,
I-
has
I-
to be finished.
I understand.
Unnecessarily means, that is my assignment.
my lord.
We'll take it up at 2.
All right.
Just.
I will try to get something written communication.
Ask them to guide a written, otherwise tell them, court will ask you to get paid.
My-
Then they may give you immediate.
But-
Yes.
5,
May I please your lordship?
Hmm.
My lord, I am the owner of undivided share of my deceased father with a plot of land matter. The said land is acquired by the GAIL for laying pipeline. And regarding compensation, my lord, some dispute there is, my lord. So may I take your lordship to the act, my lord? Section 11, 5, my lord.
Where is the act?
And give me one second.
Yes.
Page 5, section 11. The 11 portion, your lordship will find at page 6, my lord. Top.
Hmm.
Close 5. If any dispute arises as to the appointment of the compensation or any part thereof, or as to the persons to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the district judge, within the limits of whose jurisdiction the land or any part thereof is situated, and the decision of the district judge thereof shall be final. So my humble submission is that since there is a dispute, the matter may be referred to the district judge.
Fantastic. That's the only prayer.
Yes, my lord.
What is your problem? You are appearing for?
I'm waiting for the respondent of 234.
Who are you?
GAIL, Gas Authority of India Limited.
No, GAIL has no business out there. You have, your competent authority have
No,
already
no, that's
decided.
what I'm telling you. Yes, yes, I'm coming, Mala. Last occasions, when I submitted, that argument was going on, court has come to a certain finding that the court is going to impose heavy cost penalty upon the petitioners. But subsequently, their order was not passed, that's why it is coming in, because they are suppressing the entire material facts of the case. The order has already been decided by the competent authority. I am coming to that. Competent authority already decided that he is not the actual owner. He is not in his position. The land, the company should be go to the respondent number 5. I'm coming. If your lordship go through the competent authority order, page 60, that is the order. In our affidavit.
No, first of all, tell me
Yes, my lord.
whether the competent authority has the power to decide.
Yes, my lord.
Where?
Where? Yes, my lord. Consent to power to decide what of what?
Huh?
Of what amount of compensation to be determined
No, not on that.
on that.
Whether the competent authority has the power to determine intercept dispute between him and so and so.
Yes, my lord. I'm coming, my lord. I'm
Where?
coming. Yes, my lord.
Under which provision?
Because now if I have to go there, then I have to go through the entire facts. If someone
I'm not on
after
that.
receiving
I'm-
the after receiving the entire objections,
No.
while I'm coming to that, someone
I
has
am
been-
only
someone has
asking-
been issued
no,
a-
No, Mr.
someone has been
Counsel.
issued
No,
a
Mr.
both the
Counsel.
parties.
No, Mr. Counsel. I'm asking you a simple question. That is why I said
Yes.
Goel had no business. No, Gail had no business out there. I said you are only to pay the compensation.
Yes, I've already paid. I've already paid the compensation.
Whatever may be.
Yes.
But you were supposed to refer it to the district judge if there is unless you have the power to decide the dispute.
Because my lord, that they have, that's what I'm coming. Why? Why the competent authority has decided?
No. Why no? Whether the competent authority has the power to decide.
Yes,
Where? Show me.
because it has come to a finding that
Finding, forget about the finding. I'm only asking whether the competent authority has the power to decide when there is a dispute as regards the compensation.
yes, man, that someone has been issued to both the parties. He
Where?
came,
No,
I've
Mr. Counsel, kindly tell me where. Where is the power?
My lord, kindly see.
No, Mr. Alim, kindly sit down.
because that my lord, that the consent has been given.
I am not on consent. I am saying whether you have the power to decide if there is a dispute. Show me that. Please. I'm asking you a simple question.
I'm coming with a simple question, my lord.
Yes, that's
Because there's
answer the simple question.
Yes,
Where
sir.
is the power to decide? Because if there is a dispute, he has no other option but to refer. This is what happens in section 34 of the old act also,
Yes,
of the
sir.
Land Acquisition Act.
Yes,
Categorically mentioned, when there is a dispute, he will deposit the money before the competent court, before the district judge, and thereupon the amount will be apportioned. This is how the works. Show me how does the competent authority decide?
If any, he is coming to this factor because if any dispute as to appointment of compensation of any part thereof, to whom the side of party, the competent shall refer a disputed decision of a district within the limit of whose jurisdiction the land or any part is. And now, my lord, now, my lord, the district, the competent authority has passed this order because, my lord,
Mr. Alim, you just stand up for only one thing. Where have you raised the dispute that you are entitled to?
that is also disputed. That is also disputed, my lord.
No, that is not the dispute. Where? Show me that document.
Page 34, my lord.
Page?
Page 34.
Application for payment of the legitimate amounts. I am bound to intimate to you that the honor, I am so and so, I am the only son of the legal heir of heir. After the death of my father being legal, I am legally entitled for the properties of my father. So on the last so and so night at about 11 p.m., so and its son so and their family, upon raising various unparliamentary in my house and threatening to obtain my heir forcefully, hence so and so, being the legal heir of so and so, has requested to your kind honor to pay the compensation for the father's land. Then,
Your lordship, kindly turn to page 47, the FIR, my lord.
then you gave also a legal notice? Who gave the legal notice?
Legal, no legal notice, section 8.
No, page 36.
This is section 80,
What is section 8? This is a legal notice.
my lord.
Yes. Tell me. Is this your name is what? Mustafa Ahmed?
Mustafa Ahmed.
You are the son of Mukhtar Ahmed?
Yes, my lord.
Now, where in the land records your name has been recorded?
My lord, kindly come to page Bhandagular, my lord. Page
Huh?
25.
Page
25, my lord.
25. Yes. We are concerned with 663.
663, 11 to
1 bigha, 1 katha, 17 lectures.
Yes, my lord. Page 26, my lord. My father's name is indicated.
663.
663.
Tagore Mati Bahar Ali. Bahar Ali Talat.
Page 26, bottom, my lord.
Ahmed. Mukhtar Ahmed. Pita Bahar Ali. Who is Mukhtar Ahmed?
Mukhtar Ahmed is my father, my lord.
Your father's father's father is Bahar Ali.
Yes, my lord.
Firoz Ali, Pitti, Bahar Ali, Bahar Ali, Bahar Ali. So you have given. When did they pay the money? And did they issue the notice to you?
Yes, my lord.
This is on 26th of December 2018.
Yes, my lord.
Okay. Now, thereafter, what happened? Reply.
Reply given, my lord.
In the instant case, the so-and-so has been renewed and demand man to a certain detail along with When did you disburse the compensation?
This was the competition, 7621.
Huh?
7621.
What? Which?
17621.
17/6/2021. Okay. Now, what have you taken as regards his representation? What have you done?
Yes, my lord. After getting his representation, that is also after passing of the order. He has
In the representation, you have released it on 17/6/2021.
Yes.
His application to you was on 23/2021.
Yes.
Wherein
And
he
order
categorically
was-
mentioned
Yes, my lord.
that it was done under threat.
Yes, my lord. The order was passed on 23/21. That order passed by the company authority 23/21.
Maybe, but on that day, this document was received by you.
No, I have not received. I have disputed. I have denied in my affidavit. I have not received any. This is a afterthought letter he has given. There's no receipt, no postal receipt, nothing. I have stated in my affidavit also. I have denied. I have not received. This is afterthought he has made. That is the what.
Regarding my representation dated 23/2021, no averment, my lord.
Let us see where have you mentioned in your petition.
Yes, my lord. If your lord will
An
go to the
application at paragraph 7. Let us see the reply to
yeah,
paragraph
in
7.
connection with the paragraph 7, the representative department page 16, my lord. Page 16, paragraph 16, page 15 of my affidavit.
With regard to the, however, the government made in the application and denied the receipt of any such application for the basis that same is after content and vicious intent to mislead this court and to make wrongful gains in as much as the company by the postal receipt as is mentioned on the now. Duty. They are saying that you were present on 23/2021.
Regarding that, I have filed the FIR, my lord. The document they submitted that was prepared upon my signature.
Understood. But here they say you were present on 23/2021.
As per my instruction,
When did you file the FIR?
FIR was filed lately, my lord.
When?
One 8/21, my lord.
1/8/2021. After the legal notice you said. You sent the legal notice on 4/7/2021.
No, my lord.
See, Your section 80, which is, isn't it 4/7/2021? So after the legal notice, you thought of issuing the whatever may be.
Yes, madam. It was filed as per instruction of the advocate. When he came to the advocate, then he said, why did not you file the FIR? And that's because there was the COVID situation. The FIR was not filed in time, madam. I have stated in my petition. Because at the relevant point of time, the COVID was spreading, madam. Free movement was not there, madam. It's because my petition was filed to the authority on 23/2021. And the occurrence happened on 24/2.
Page 100 and,
Yes.
where is his affidavit? Mr. Mitro, where is his affidavit? Where he has given the no consent, yeah?
Yes, madam, I'm just coming.
114.
Yes. 55, 65, my lord, page.
What type of affidavit is this? It doesn't have any, no swearing, nothing.
Yes, all signatures there behind the back.
You have been practicing for long, Mr. Mitra. I know, I think you know how an affidavit is to be sworn. Does it have any details, any essence, any, it has to be, affidavit has to be sworn before an authority?
No, no, my lord, if you want to go to page 64, my lord.
64 is an e-stamp.
Yes, my lord.
Does the e-stamp make it an affidavit? Isn't an affidavit required to be filed before an authority, either a notary or before a oath commissioner? Can you take an oath just by stating out there?
Moreover, it does not bear my signature, madam.
And my lord, and if
No
you want to-
signature, that Mustafa Ahmed.
Mustafa Ahmed's signature seems to be appeared at page 66. And regarding this, the FIR has been filed, madam. The stamp signature obtained in blank document. Subsequently, this is prepared.
you will also go to page 63, my lord. If you will also go to page 67, 62. This is the, my lord, he has stated I have no objections. 62, my lord. With due respect, this is stated that the land in 663 to which the parallel project is passing through has been in the name of my brother Faiz Ali. That is, therefore I have no
Then,
objection.
Mr. Counsel, tell me, does page 63
Yes.
and page 66,
Yes, my lord.
the signature of the person is same?
And its signature, my lord. 67, 68, there his voter list and other things. Yes, signature and this signature is the same.
Voters list, where is the signature? Signature is of the authority. Where is the signature in voters list?
Voter list, my lord, page 67.
Then,
Electoral Commission.
these are by electoral officers. Then,
Yes, my lord.
why you are making these statements? And there is a dispute, it is the duty of you to send it.
And my lord, page 50 will also give page 58. He was present, my lord, at the time of hearing, my lord. Yes, putting his signature.
Whether
also.
you say he is present, he says he was not present. How can this court decide? So why didn't you could have, why are you not referring it out there and let the competent court decide that?
My lord, what is the basic thing is that?
No, what
the
is your
pipeline-
problem? No, I don't understand, Mr. Mitra. What is your problem? You have to pay a particular amount you have already paid.
Because.
Why is it, what is the problem in making the
because
reference to
this-
district
My
judge?
lord, the disbursement already been made.
So what?
So if the court says that you return back, is it possible?
Absolutely, you are to return if
Yeah.
it is false. If it is a false, you shouldn't have acted because of your officer who has done it. The signatures doesn't match. You have no business out there when there's a dispute to decide that. And once there's a dispute, why haven't you referred it? They're not done. You should have referred it at least to, if the authority you prove out there that look here, this person came, these are the people who have come out there. There will be his brothers who will be there who can prove it. Yes, this person was there.
And your
But
lordship,
can
what
this
you,
court
what
decide
you,
this?
what your lordship, you just asked me one question, my lord, whether this is a, whether the competent has the power or not. If your lordship go to 11, section 11 of the act, say
What?
11.4.
Section?
11.4 of the act,
Yes.
deposit and payment of compensation.
Hmm.
It is written, where several persons claim to be interested in the amount of compensation deposit under subsection 1, the competent authority shall determine the person who is in his opinion entitled to receive the compensation and amount payable.
This is regarding the apportionment.
Yes, my lord.
If there are many persons who are entitled to, then you are going to decide how much you will go there. But if there is a dispute, you have no power. You see, then 5 comes. If any dispute arises as to the actual apportionment of the compensation or any part thereof, as to the persons to whom the same or any part thereof is payable, the competent shall refer it to the DO. So you have no business out there to do that. Third, dispositor. Mr. S. Salim, the learned counsel, appearing on behalf of the petitioner. Mr. Who appears for union? None appears on behalf of the respondent number 1 on call. Mr. S. Mitra appears for respondent number 2 and 3. 2, 3 and 4? No, 4 you are not.
4, I am actually the state government should represent, but no, none appears for state government.
Okay. No, state you won't represent. You have appointing him as a competent authority, deputy secretary to the
Normally what
government of
happens,
Assam,
I am telling you.
and the competent authority, government of India. You represent 2, 3 and 4. As your affidavit is on the basis thereof, 2, 3 and 4. So taking into account the matter involved, the instant writ petition is taken up for disposal at the motion stage itself. It is further made clear that for the purpose of this, as the dispute involved herein relates to exercise of powers, it relates to the inaction on the part of the respondent authorities, more particularly the competent authority, not exercising the powers under section 11F, 11.5 of the Petroleum and Mineral Pipelines bracket acquisition of right of user in land bracket close Act 1962. Notice upon the respondent number 5 is not found necessary. Accordingly, this court therefore proposes to dispose of the instant writ petition as herein under. The case of the petitioner herein is that the petitioner claims to be the grandson of one Bahar Ali, since deceased, who was the original pattadar of a plot of land measuring 1 bigha, 1 katha, 17 lechas, covered by Dag number 663 of patta number 124, situated at Revenue Village number 1, Dobok, under Pub Borigog, Moja, in the district of Kamrup, Assam. It is the further case of the petitioner that after the death of the petitioner's grandfather, late Bahar Ali, the names of his 4 sons, namely number 1, Mukhtar Ahmed, bracket, the father of the petitioner. Number 2, Firoz Ali. Number 3, Faiz Ali. And number 4, Fakhruddin Ali Ahmed, have being the legal heirs, were duly mutated against the said plot of land by an order dated 30/11/2016, passed by the concerned circle officer. Under such circumstances, it is the case of the petitioner that the father of the petitioner became the absolute owner of 1/4 share of the entire land of Dag number 663, measuring 1 biga, 1 katha, 17 lecha, which was something which would be something more than 1 katha, 14 lechas. It further appears from the records that the respondent that it further appears on record that a notification SO number 5321 dated 10th of October 2018 was issued by the Ministry of Petroleum and Natural Gas of the Government of India on 16th of October 2018, whereby in public interest, the right to use, it's right to use, no?
Right to use.
The right to use of various plots of land was to be acquired for laying of the Barauni Guwahati gas pipeline by GAIL India Limited for transportation of gas. The said acquisition was to be done in terms with the provisions of the Petroleum and Mineral Pipeline Acquisition of Right of User in Land Close Act 1962. Pursuant thereto, notices were issued, individual notices were issued to the various patadas, including the petitioner herein, as could be seen from Annexure 3 to the writ petition. It is the case of the petitioner that on 24/2/2021, one Faiz Ali, along with his sons, obtained certain signatures by threatening him. Thereupon, the petitioner submitted an application to the respondent, to the competent authority. Whom, Mr. Alim, whom did you give it? To the competent authority.
Yes, ma'am.
To the competent authority on 23/2021, stating inter alia that he has a right to compensation in respect of Dag number 663, which also belonged to his father. It further appears from the records that on 4/7/2021, a legal notice was issued under Section 80 of the Code of Civil Procedure demanding payment of full compensation to the petitioner in respect to the land so acquired, in respect to his entitlement insofar as Dag number 663 within a period of 15 days. To the said legal notice so issued by the petitioner on 16/7/2021, the respondent competent authority through its lawyer had replied to the same, stating inter alia that the said order on 23/2023 was passed by the competent authority upon hearing all the parties, including the petitioner, and thereby for releasing the compensation in favor of the respondent number 5 herein. It was further mentioned that the written consent was given by the petitioner to release the compensation in favor of the respondent number 5. It further appears that the no objection certificate was also given by the petitioner as stated in the said reply, and the compensation has been disbursed by the competent authority upon receipt of the stated documents. It further appears that after the issuance of the legal notice by the petitioner on 1/8/2021, an FIR was filed before the officer in charge of Dobok Police Station narrating the incident dated 24/2/2021. Full stop. Accordingly, a case was registered being Rangia PS case number 806/2021 under section 506(420) IPC. Subsequent thereto, on 5/8/2021, the petitioner again requested the competent authority, that is the respondent number 4, to refer the matter, and till then refer the matter in terms with section 11(5) of the Act of 1962. Until then, the compensation should not be disbursed to the respondent number 5. It is the further case of the petitioner, as the respondent's authorities did not take any steps in consequence to the request made on 5/8/2021, the petitioner had filed the instant writ petition on 8th of November 2021. It appears on records that on 17/11/2021, the respondent numbers 1 to 4 were duly represented. And as such, this court directed for serving extra copies of the writ petition so that they could take instructions in the matter, and accordingly fixed the matter on 23/11/2021 for motion. On 23/11/2021, when the matter was again listed, the learned counsel appearing on behalf of the respondent number 2, 3, and 4 submitted that the petitioner failed to place on record that the said application dated 23/2021 as well as the application dated 5/8/2021 alleged to have been submitted by the petitioner before the concerned authority of the respondent Gail, as those documents do not contain any seal and receipt number of the authority concerned. It was further mentioned that the respondent number 5 have already been released them an amount of ₹4,45,165 in terms with the order dated 29/2021. This court thereupon directed the respondent number 2, 3, and 4 to place the relevant instructions in the matter on the next date fixed. It was further made clear that in the meantime, for the land of dark number 663, the respondent Gail shall not release any further amount to the respondent number 5 until further orders of the court. It further appears from the records that on 13th of December 2021, the chief manager construction of the respondent number 2, being authorized by the respondent number 2, 3, and 4, had filed an affidavit in opposition. The contents of the said affidavit is parameter to the legal notice, reply to the legal notice so served, reply to the legal notice issued by the counsel appearing on behalf of the respondent number 2, 3, and 4. In paragraph number 13, it has been mentioned that on 23/2021, the petitioner was present along with the sons of the respondent number 5 and various other persons. It was mentioned that the field personnel of the respondent number 2 and 3 had seen the petitioner, his wife, and the sons of the respondent number 5 in the field, in person, in the field, during the course of the hearing on 23/2021. It was also mentioned that the petitioner had submitted his voter ID card issued by the Election Commission bearing number HBP 1851894, which was also verified with the original. In paragraph number 16, which is the reply to paragraph number 7 of the petition, it was the specific stand taken by the respondent number 2, 3, and 4 that the application dated 23/2021 was never received by the respondent numbers 2, 3, and 4 at any point of time. When did you pay the money? Where is it mentioned?
Yes.
Page 18, madam.
Huh?
Page 18,
Yeah.
80
18
of
of affidavit, madam.
Page 15, my lord, page 14. Paragraph 14, page 14.
where? Ah,
7621.
in paragraph number 15, it is relevant to take note of. Now, it is relevant to take note of that in paragraph number 15 of the said affidavit in opposition, it has been mentioned that on 17/6/2021, an amount of rupees 4,45,165 being the final compensation amount in terms with the subject plot of the land was disbursed by the respondent number 4 in favor of the respondent number 5 directly into her bank account by the NEFT bearing UTR number BAR BZ2 11686 95155. It is also relevant to take note of that in Annexure J to the petition, to the affidavit in opposition, the order dated 23/2021 was enclosed. Wherein it has been mentioned that the petitioner was very much present on 23/2021 at 10 a.m. It is also seen that the compensation was to be released in favor of the respondent number 5, subject to the following condition, that she submits an indemnity bond What is this ROU?
Right of uses, right of uses, right of uses.
Indemnity bond. Next. I've heard the learned counsels for the parties and perused the materials on record. The learned counsel appearing on behalf of the petitioner submits that the competent authority in terms with the Act of 1962 has no jurisdiction or authority to decide the entitlement of the compensation when a dispute arises. In such case, in terms with section 11(5) of the Act of 1962, the only jurisdiction left with the competent authority is to refer the parties to, make a reference of the dispute to the decision of the district judge within the limits of which jurisdiction the land or any part thereof is situated. And the decision then of the district judge then shall be final. Referring to the communication dated 23/2021, as well as 5/8/2021, the learned counsel appearing on behalf of the petitioner duly submitted that the petitioner duly informed the respondent competent authority not to grant the compensation as the petitioner was entitled to. It was also informed that the undertaking so taken on 24/2/2021 was also under force and coercion. And in spite of that, as could be seen from the affidavit in opposition dated 17/6/2021, the affidavit in opposition, that on 17/6/2021, the amount has been released in favor of the respondent number 5. Referring to section 11(4) of the Act of 1962, the learned counsel appearing on behalf of the petitioner submitted that the power of the competent authority to apportion the compensation would be when there is no dispute between the parties. And it is only in the eventuality, it is only when but when any dispute arises, the competent authority has no jurisdiction to decide such dispute. On the other hand, Mr. S. Mitra, the learned counsel appearing on behalf of the respondent number 2, 3, and 4.
If I want to dispute, some factors have to be taken into consideration, observation has to be made. So normally, the competent authority, the GAIL, will pay the compensation only on those portion of the land upon which the pipeline has been laid down. So that portion of land belongs to the respondent number 5.
I am not on these, Mr. Counsel. I've only recorded his argument.
Yes, my lord. No,
Let me record your argument.
Yes, my lord.
You sit down. If you have any grievance, there's the division bench out there. Go there. On the other hand, Mr. S. Mitra, the learned counsel appearing on behalf of the respondent number 2, 3, and 4, submitted that the instant writ petition is nothing but an afterthought. Inasmuch as neither the communication dated 23/2021 nor the communication dated 5/8/2021 was at any point of time received by the respondent authorities. And this aspect of the matter would be evident that there is no sign, seal, or any endorsement made by the respondent authorities. Referring to paragraph number 16 of the affidavit in opposition, the learned counsel submitted that it is the specific categorical stand of the respondent authorities that the communication dated 23/2021 was not received. The learned counsel further submitted that the fact that the entire proceedings as well as the litigation is an afterthought can also be discerned from the fact that there was no affidavit and there is no FIR filed in respect to the incident dated 24/2/2021 till 1/8/2021. And thereupon, the petitioner took steps after coming to learn that the amount of rupees 4,65,000 odd amount was disbursed to the respondent number 5 on 17/6/2021. The learned counsel further submitted that from a perusal of the order dated 23/2021 issued by the competent authority, it is also clear that the petitioner was very much present before the competent authority. And he had no objection when the amount was to be paid to the respondent authorities, to the respondent number 5. Yes, tell me.
No, my lord, I was point out, in the observations, in the orders given by the competent authority, categorically competent authority stated why we have paid the amount to respondent number 5. One point is that the pipeline, although it is the land 663 dug has been taken out, but only the pipeline has been laid down on over a plot of land which is owned by the respondent number 5. And he is not in possession of that plot of land.
I'm not concerned about possession. 663, are you taking or not?
I'm
The
saying,
right
no,
of
no, no.
user.
Right to enter land I have not taken.
Are you taking the right of user on 663?
663 on only one some portion.
Whatever may be. Now, if there is no division amongst them, can you say this portion or that portion? You can't. Unless there is a partition.
No, there is partition. This is a fact, my lord.
What is the fact?
No,
There's no partition.
There is no partition.
So under such circumstances, that this portion of the land will be this portion of the land in whose favor it is. How can you assert it? Unless it is written in every part of the block or soil or out there that this belongs to
That's what I'm telling my affidavit. In presence of Lat Mandal, circle officer, everywhere present, that inquiry has been made.
Mr. Mitra, are you saying that you are not paying the compensation for 663?
I'm paying you for.
No, are you saying that you are not paying the compensation for 663?
Yes, I'm paying.
Now there is an indemnity bond which is there.
Yes.
And I know what is written out there in the indemnity bond. The indemnity bond says that if in any future the amount you are not entitled, you are liable to be returned back. So you are protected out there. Unless you fear that there is some hanky-panky done by your officials. Is it your admitted fact?
That I don't know.
Then why you are worried? You are well protected with all this 4,65,000. There is an indemnity bond which is to be given. The indemnity, if there is any decision made by the authority concerned, that will be done. Well, how are you concerned with that? And I don't think you are espousing the cause of the respondent number 5 separately.
No.
Then?
But the only thing is that he should not penalize double. That respondent, the Gale should not be penalized for double payment as to. He should not be penalized for the same.
Who?
The Gale should not be penalized for that. That he has to pay. If the order has been passed.
You
like
recover it from your officials if you have done so. If tomorrow on findings of fact right there, it is found that no, nothing was there. This person was not there. Then what happens?
No, my submission only that, only that, only.
If that is so, if the GAIL is liable to pay, then you recover it from your hiring officials. I'm coming in 5 minutes. Counsels for the petition parties and have perused the materials on record. The issue involved in the instant writ petition, as could be discerned from the pleadings as well as also from the materials on record, is as to whether the respondent authorities, competent authority, that is the respondent number 3, was justified in not making the reference in terms with section 11(5) of the Act of 1962. It is on account of the specific issue involved. This court is also of the opinion that the presence of the respondent number 5 is not required for the purpose of deciding the instant dispute. Section 11(4) and 11(5) of the Act of 1962 being pertinent is reproduced here in under. 11(4) and 11. A conjoint reading of the above two provisions would clearly show that when several persons claim to be interested in the amount of compensation deposited under subsection 1, the competent authority has been empowered to determine the person who is in its opinion are entitled to receive the compensation and the amount payable to each of them. However, section 11(5) comes into play when there is a dispute amongst the several persons, in respect to the apportionment of the compensation. In that circumstance, it is outside the jurisdiction of the competent court authority to decide the said dispute, and the only authority left to the competent authority is to make a reference to the district judge, within the limits of whose jurisdiction the land or any part thereof is situated. The facts, as have been detailed out in the previous segments of the instant judgment, clearly shows that there are disputed questions of facts, in as much as it is the specific stand of the petitioner that on 23/2021 and on 5/8/2021 he had submitted a representation to the competent authority. On 23/2021 and 5/8/2021, he has submitted representation to the competent authority, stating inter alia that the no objection certificate, no objection so given, was taken by the respondent, number 5 and her sons forcefully on 24/2/2021. On the other hand, it is the specific stand of the respondent numbers 2, 3, and 4 that the competent authority never received any communication dated 23/2021 and 5/8/2021. It is the further stand of the respondent number 2, 3, and 4 that the petitioner was very much present on 23/2021 before the competent authority, who had duly consented in payment of the compensation to the respondent number 5. These disputed questions of facts, however, cannot be decided in the proceedings under Article 2 to 6 of the Constitution. And it can only be decided in a forum where disputed questions of facts can be dealt with on the basis of the law of evidence. A perusal of Section 14 of the Act of 1962 clearly shows that there is a bar of jurisdiction of the civil court. In respect to various aspects, including in respect of any action taken or proposed to be taken in pursuance of any power conferred under this act. Therefore, the civil court cannot decide the inter se dispute between the petitioner and the respondent number 2, 3, 4, and 5. It is also well settled that a person cannot be made remediless inasmuch as any statute which renders any action to be without remedy would be affecting the rights under Article 14 of the Constitution. On the other hand, if this court takes into consideration Section 11(5) of the Act of 1962, it empowers the competent authority to make a reference to the district judge when any dispute arises as regards the apportionment of the compensation or any part thereof, or as to the persons to whom the same or any part thereof is payable. The said provision does not limit the powers of the competent authority if the compensation have already been disbursed. And the same can duly be done even after the compensation is disbursed. It further appears from a perusal of the order dated 23/2021 that while disbursing of the amount of compensation, the respondent number 5 was required to furnish an indemnity bond. During the course of the hearing, this court further inquired with Mr. S. Mitra, the learned counsel appearing on behalf of the respondent number 2, 3, and 4, as regards the contents of the indemnity bond. And it was submitted that the indemnity bond is given for the purpose that if in any later point of time a dispute arises, the person receiving the amount shall indemnify the respondent authorities, the competent authority. Under such circumstances, this court therefore is of the opinion that in view of the disputes which has arisen, and this court is not in a position to decide the said dispute, as it would be necessary to go into the intricate details of evidence. It would be in the interest of justice that a competent authority makes a reference to the district judge insofar as the entitlement of the petitioner vis-a-vis the respondent number 5. The district judge can very well decide as regards the veracity of the statements so made to the effect that the petitioner had submitted veracity of the statements of the claims and counterclaims so made by the petitioner as well as the respondent number 2, 3, and 4, and also take into consideration the stand of the respondent number 5. Accordingly, this court therefore disposes of the instant writ petition with a direction to the respondent number 4 to make a reference to the district judge. Where?
Kamrup Aminggaon.
District Judge Kamrup Aminggaon within 15 days from the date of receipt of a certified copy of the instant order, and the learned district judge thereupon shall do so. Shall decide the dispute in accordance with law. With the above the petition stands exposed.
Obliged, ma'am.
Item 45, part heard matter.
This is the case, my lord, of the EDOs and CEOs being given same grade pay. That they
Where is the finance? Who is creating all the problem?
Lordship is on his way. The council B Gogoi is on his way. Lordship, council B Gogoi is on his way.
We are having a change in the council.
No, Lordship.
I hope this change also the stand.
basically finance is, my lord. Finance stand is that the recommendation of the pay commission is the gospel truth. But the paragraph 8 of that recommendation, which is clumsy, my lord, the government said that this recommendation will be subject to the service rules. Therefore, the service rules shall prevail.
Yes, Mr. Goi.
Well, so these two cases, my lord. But probably our board Pujari was appearing, but I'm not aware of this particular case.
Where is he?
In fact, Lordship is directed to produce some ROP rules.
That he has produced it.
My lord.
Where is Arup?
After some time, my lord, it's coming.
Okay. We'll take it at 2. You can. No. Let me take up the other matters now.
I have completed my argument. I'll just summarize.
No, I have got it. What your basic submission is the deputy CEO is a promotional post of the BDO, and for that it requires 10 years of experience as per the service rules. Now what they have done, they have now given the BDO the same scale of pay as that of you.
Great pay.
Great pay. And as such, your basic submission is that you can't do that because I am in a promotional post. It will amount to defeating or violating the particular year.
Precisely that is the case, my lord. Precisely that is the point, my lord. There is no way that a person serving in the higher rank should get the same pay received by the lower rank on planet Earth.
And that too when it is a promotional post.
That cannot be done on planet Earth.
It happens.
But otherwise he's coming, my lord. He is coming.
At 2.
We'll see that too. I'll take up the other matter.
Oh, yes, come.
Oh, yes, come.
Thank God.
And where is your adversary counterpart?
One side has supported us. They have filed affidavit recommending.
Yes, tell me. What else? You were showing a particular judgment. Tell me which judgment. On 2019 something. (2019)
Yes, my lord. It is 2019 18 SCC.
Huh?
18 SCC.
18 SCC. Page?
Page 301. Let's may kindly come to paragraph.
Wait. Our internet is not so fast. Oh, this one. This I remember this judgment.
Paragraph
This is a different. This is the judgment on those two type of teachers, where you cannot. Although it has been categorically mandated that they are doing the same work, everything is there. And then it was said that Jagjit Singh's judgment, which is there, that judgment did not take into consideration the source of recruitment also. That is the aspect. And as such, it was said that although these people may be doing the same work, everything, but then also they cannot be given the pay parity.
For a moment, for my satisfaction, if my lord comes to paragraph 96.
90?
96.
Wait. Yes, still down.
Paragraph 96, my lord, apex court has laid down the parameters.
Not necessary. Wait. By the time it comes, I hope the internet improves.
Because this judgment I am relying for the reason that my lord had called for the ROP rules, relevant ROP rules, which does not figure out the pay scale pertaining to either CEO or deputy CEO.
Then, but the service rules does.
Service rule does, and
Then does the service rule is overridden by the pay commission, and that too when the pay commission acceptance is a policy decision.
Now, ROP rules are, my lord, 309 rules.
Understood. ROP rules are 309, understood.
That is also
But
309.
ROP rules, it becomes a rules later on.
Yes.
But by way of an ROP rule, can you change the service rules?
But, I have been searching for some judgments.
There's no, that cannot be so, because otherwise it will have a disastrous effect.
No, but
Unless prior to that, and those persons who have now got appointment out there, because the ROP rules was approved only on the year 2017.
yes,
These people have got their promotion on 2016 to a particular post. I would have understood. In respect of later on, you may very well say something, but not of those persons who are there in 2016.
yes. So in the bunch of papers, the relevant ROP rules, which I have produced before my lord on the last occasion,
Yes.
Lordship has kept it as a part of the record. There, my lord will find.
You have not done it only because of the fact that the PNRD department says out there that they have not approached the anomaly committee. You say that they have submitted representation after representation. That is a different thing. They should have approached the anomaly committee for their correction. Now, having not done that, can you deprive his rights? That is the question.
But Pay Commission has taken on board, my lord, their objections, their representations,
They
everything.
have not taken the of their objections and their representation. No,
it is there.
no. The Pay Commission have taken the of various associations. See,
Yes, association. They are espousing
not
the
there,
same.
not his.
Not his, may not be his.
Then,
but the
without
process-
hearing them, can you change the service rules? You will have a far-reaching effect.
No, one argument, my lord, that I am developing at this stage, my lord,
Yeah.
of course, subject to my, on the basis of the.
Yes,
advocate
paragraph 96.
96. Lordship got it.
Hmm.
Analysis of the decisions referred to above shows that this code has accepted the following limitations or qualifications to the applicability of the doctrine of equal pay for equal work. The doctrine of equal pay for equal work is not an abstract doctrine. The principle of equal pay for equal work has no mechanical application in every case. The very fact that the person has not gone through the process of recruitment may itself, in certain cases, make a difference. Then, my lord, the application of the principle of equal pay for equal work requires consideration of various dimensions of a given job. Thus, normally, the applicability of this principle must be left to be evaluated and determined by an expert body. These are not matters where a writ court can lightly interfere. Then, my lord, it further says, granting pay scales is a purely executive function, and hence the court should not interfere with the same. It may have a cascading effect, creating all kinds of problems for the government and authorities. Equation of post and salary is a complex matter which should be left to an expert body. Granting of pay parity by the court may result in a cascading effect and reaction which can have adverse consequences. Before entering and accepting the claim based on the principle of equal pay for equal work, the court must consider the factors like the source and mode of recruitment appointment. So these are the parameters that has been laid down, my lord, by the Honorable Apex Court. Here in the ROP rules, therefore, my lord, I am making that submission. But you will kindly hear. In the ROP rules, my lord, it has been specifically laid down, born out of ACS cadre, born out of a specified cadre. Now, if a person is, my lord, recruited through a selection process by a public service commission, it is more rigorous. It is a rigorous selection process. And if a person is, my lord, recruited, my lord, through a less rigorous selection process, both have entered into the government service, then, my lord, the difference has to be taken on board. This is what the Apex Court says, because mode of recruitment.
Understood. But are you saying the BDO and the deputy CEO is recruited by different things, different rules?
No, not.
Then why are you making that submission? We are not concerned with all those things.
No, because
No, Mr. Bhattacharya, all these submissions are too far-fetched.
Because the expert.
No. This is too far-fetched because of the fact.
Understood.
Now let us. You see, you have to understand the judgment in the perspective on which the matter was there. The judgment was delivered on the facts that whether these school teachers, now if you see this particular judgment here, where they deal it, and more particularly, I think of Justice Sapre.
Yes.
Wait.
Supplementing part, my lord, it starts from paragraph
You
112.
get the answer from that particular thing. Wait. Not here. Kindly come to paragraph. Yes, 106.
106.
Yes,
Yes, ma'am.
read it. These are the facts.
In our considered view, there has been no violation of the rights of the music teachers, nor there has been any discrimination against them. We do not find that the efforts on the part of the state government could be labeled as unfair or discriminatory. Consequently, the submissions as to how the funds could and ought to be generated and what would be the burden of the state government and the central government do not arise for consideration. In our view, great strides have been made by the state in the last decades. It has galvanized itself into action and not only achieved the objectives of having schools in every neighborhood, but has also succeeded in increasing the literacy rate. It has also succeeded in having more girl children in the stream of education, and consequently the TFR, as indicated above, has also improved to a great extent. If these are the benefits or rewards which the society stands to gain and achieve, the state ought to be given appropriate free play. The tabular charts placed on record by the state also show continuous improvements made by the state in the packages made available to the Neogic teachers. The state attempts also show that the state is moving in the right direction, and the gap which is presently existing between the government teachers and the Neogic teachers would progressively get diminished. Considering the large number of Neogic teachers as against the government teachers, the steps taken by the state, as evident from various tabular charts presented by it, are in the right direction. At this juncture, any directions as have been passed by the High Court may break even tempo which the state has consistently been able to achieve.
Then 107.
At the same time, the submission that at the initial stage, the Neogic teachers are given such emoluments which are lesser than peons and clerks in the same school is a matter which requires attention. It is true that after having put in 2 years of service, the emoluments made available to the Neogic teachers show some improvements, but the disparity at the initial stage is more than evident. The state may certainly be entitled to devise a pay structure for Neogic teachers, and the courts may not interfere in policy matters. But if there is an imbalance of the nature as presented before this court, the matter raises concern. The teachers must be entitled to decent emoluments. In the chart referred to in paragraph so and so above, after 2 years of service with proposed enhancement, as per recommendations of the 3-member committee, the states payable to the Neogic teachers would show some increase as against those in respect of peons and clerks. The state may consider raising the scales of Neogic teachers at least to the level suggested by the committee without insisting on any test or examination advised by the committee. Those who clear such test or examination may be given even better scales. This is only a suggestion which may be considered by the state.
Now kindly come to page one, paragraph 101.
101. Heavy reliance was placed on the aforesaid decisions by the learned Attorney General and the learned counsel who appeared for the state. It was submitted that though the teachers in provincialized cadre and the state cadre were doing similar duties and discharging identical responsibilities, and though they were, as a matter of fact, drawing similar pay and emoluments, the services were considered to be distinct and different. The feature that one of the cadres was to be a dying or vanishing cadre was also present in those cases. It was accepted by this court that the state was within its rights to let a particular service or cadre be a dying or vanishing cadre and keep making appointments in other service while maintaining distinct identities of both the services, even when the teachers coming from both the cadres were doing identical jobs. Though strictly speaking, these two matters did not involve concept of equal pay for equal work, these cases do point that the state can validly make such distinction or differentiation. The learned Attorney General and the learned counsel appearing for the state were therefore justified in placing reliance on these two decisions. It was also evident that the subsequent judgments have not noted the decisions of this honorable court in Joginder Singh and Jabbar Singh. For the purposes of the present discussion, we will proceed on the basis that even when the teachers from both the cadres were discharging similar duties and responsibilities, the decision of the state government to maintain different identities of these two cadres was not found objectionable by this court. And further, there could be inter se distinction between these two cadres. It is true that both the cadres were enjoying same pay structure, but the submission that the chances of promotion ought to be similar was not accepted by the court. Now, my lord, if my lord again comes to para 96, why I am my lord submitting? Before that, my lord, the recommendation of the pay commission, which is there on record in my affidavit also at page 93. What is the recommendation? Pay commission says at clause 8, my lord, the post of deputy CEO, BDO senior grade, and the BDO shall be put in the same pay scale of GP, grade pay of rupees 5,400. The designation of BDO senior grade be abolished, and the officers posted in the Jila Parishad be called deputy CEO, and those posted in the blocks be called BDO, both having the same GP of 5,400. As a consequence of this, the EO Group B can be posted on promotion either as deputy CEO or as BDO. So this was the recommendation. Now, whether this recommendation can be sanctified within the four corners of law, for that reason, my lord, I am relying at para 96, which says, my lord, granting of pay scales is a purely executive function, and hence the court should not interfere with the same. It may have a cascading effect, creating all kinds of problems for the government and the authorities. I pause here, then I come, my lord, to the penultimate page of my affidavit, that is the endorsement of the finance department, which says, the last but the second paragraph, in view of the above, PNRD department is requested to clarify if there are any other posts under PNRD department with grade pay of rupees 13,300 and the possibility of those incumbents again claiming for higher pay if the grade pay of deputy CEO is upgraded. So the financial implications.
Understood. Mr. Babujari, these aspects have been duly done and taken and trusted out there. The fact that is why on the last occasion I asked them to produce this ROP because what was happening is the finance told the PNRD to do that, but the PNRD did not do anything, and as such the matter has come up now. Although these matters have been going on during the pendency of the writ petition, be it as it may, out there there is another post which is there in the ROP, if you see here. The assistant, who is getting now 13,300?
There, my lord, will find that the Directorate of Panchayat, at my lord, the third page of the fourth page of the bunch of papers.
278.
Yes, my lord, and so obliged. Assistant Development Commissioner, my lord, there, my lord, will find a grade pay of 13,300.
Okay.
And so therefore, on the last occasion, my lord has made a pointed query to my colleague. as So how come this CEO and deputy CEO are functioning in the PNRD department and how they are recruited and how their services are affected by this 2013 rules? Because the dispute herein has arisen only because of these two posts. Deputy Chief Executive Officer. Deputy Chief Executive Officer, my lord, finds mention in the rules, but the CEO doesn't find any mention in the rules.
CEO is not there.
Yes, it is not there. So therefore, the expert body has recommended that you club this post. Only thing my lord is anxious upon that at an earlier point of time, they were promoted, my lord. They had already been discharging their duties. Now you cannot turn the clock back. This is precisely what I understand, my lord, for the moment. That rules, my lord, will find that page 36, relevant portion. Page 36.
No, I mean, Mr. Devnath, is there any CEO?
Yes, ma'am.
Where?
Well, he's an ACS employee, madam. He's an Assam Civil Service employee. He's from the government of Assam. So he's inducted over there.
So the payment is not made from them. Payment is not made from the department.
As for the last is concerned, my lord wanted to know what the gate pay was. I've been able to get that. But payment is made from whom, my lord, I'm not aware. Because the list that is mentioned over there, these are all PNRD employees.
Huh?
These are all PNRD cadres, my lord. These are not Assam Civil Service employees.
But where is it?
Well, if my lord will have a look at Schedule 2, my lord.
Huh?
Whether it's next over there.
Schedule? No, but the rules does not say anything by promotion or direct recruit. Does they say anything? Because the cadre, there is no CEO.
My lord, kindly have a look at our affidavit, my lord.
No. Let us see from the rules. Show me where the CEO is.
CEO is not met.
Not there.
No.
Then where do you bring the CEO?
CEO is actually would be senior to the Assistant Development Commissioner. And on the last date, my lord was actually we were all actually puzzled by the fact that in Rule 3 it was mentioned that after the Deputy Executive Officer, it was the Assistant Development Commissioner whose name was mentioned. My lord, actually, that is not the actually right criteria as far as their seniority is concerned. We'll have to have a look at Schedule 2, my lord. That provides the exact
Schedule 2 of
the
rules.
The rules.
Schedule 2. Where do I get the Schedule 2? Oh. Yeah. Got it. Additional Director Promotional, Joint Director
Seal number
Promotional.
10, my lord.
Huh?
The Assistant Development Commissioner is at seal number 8.
Yes.
And at 10 is the Deputy Executive Officer. And at 11 is the BDO.
But the Assistant Development Commissioner comes from the fishery.
Yes.
They don't have the independent here. They are from Extension Officer Fisheries.
Yes.
From there they will go.
Yes.
Now, but from Deputy Chief Executive Officer Jila Parishad, it is from BDO.
Yes, sir.
It's a promotional
100%
post from
promotional
BDO.
post.
BDO.
That's
Now
what
BDO is also direct you can have as well as promotional. The promotion happens.
That's why the affidavit is concerned. We've said that the entire deputy CEOs are concerned. There is a 100% promotion.
No. I'm saying about BDO.
From the BDO.
Understood. But BDO is direct and partially promotional. Unless you have changed the rules. It mentioned it direct and promotion.
Yes, ma'am. It will be direct and promotion.
Yes.
So
From extension officer, promotion to BDO.
So mode of recruitment to the post of additional director shall be either IS, AS, so and so, recruitment to the 60% cadre of the joint director, so and so, to 80% of the deputy director, vice principal, so and so shall be made promotional and 20%. Recruitment to the 100% for the deputy chair from shall be made, so and so. To the assistant development officer shall be made by promotion. Recruitment to the block, 40% direct recruit and 40 from the extension officer. Now, if you see it down below, further,
Petition.
If you see page 39 of the petition, 100% of the strength of the cadre of Assistant Development Commissioner shall be filled up by Extension Officer Fisheries. Okay, now how do you bring the BDO? 60%, how do we have 20% of the clear comes from Extension Officer credit?
This one.
So from Extension Officer, a post of Extension Officer, which is a serial number having the same at 3G1G of the rules. The ranking is equivalent.
But for the proper ranking, we'll have to have a look at the schedule 2 .
Now here it is said Extension Officer has been included, Extension Officer Fishery, so and so, so and so, so and so. Doesn't it mean the same in 3G1G?
They are equivalent. All the extension officers.
So therefore, from Extension Officer Fishery, a person is 100% recruitment to promotional to Assistant Development Officer.
Yes, ma'am. From the fishery department.
From Fishery.
Yes, ma'am.
So this is 100%.
Yes.
Now from Extension Officer Credit and Extension Officer Panchayat, which is equivalent to Extension Officer Fishery, 60% goes out there to promotion to BDO, which is at the F, and 40% is direct recruit. Now from BDO, it goes to the deputy CEO.
Yes, 100%.
Now, if you see the schedule, interestingly, Assistant Director, we are concerned with page 45.
It would be.
What they have done is they have increased the block development officer from 4,700 to 5,400.
That was actually not the scale pay, madam. That was something else. That was actually.
It's 4,700.
Scale pay was, I think, 12,000 something. 12,000.
No, I'm not on 12,000 business. I'm on not the pay. I'm saying about the grade scale. Grade pay.
Grade pay was 5,400.
The problem is with PB4. The block development officer was in PB3. They were made to PB4. Whereas the deputy chief executive officer was in PB4. If you see the schedule. Kindly come to page 45 of the petition.
Yes, madam.
See, block development officer, 8,000 to 35,000. And if you see it out here in this page, which he has given last time, you see?
Yes, madam. The grade pay is 5,000.
Yes, yes. Now this is PB3. Payment 3. Now they have been increased to PB4.
Yes.
They have increased it to the block development officer. But the persons who were in PB4 were the deputy chief executive officer. If you see here, here,
He was getting
number
a grade
10.
pay- He was getting a grade pay of 5,400. madam.
Now 5,400 is okay. But you see, deputy chief executive officer, Jila Parishad, 12,000 to 40,000. This is PB4. If you see corresponding with here, it's PB4.
It is PB4. madam.
Now, therefore, what they have recommended is bring them into PB4 and give them the great pay, which the deputy CEO has done. And the finance have readily accepted that. But they are not willing to give it to the 9 or 16 people.
Madam, as far as our stand is concerned, we support the stand of the petitioners, madam. as far as us is concerned, we support the stand of the petitioners. We are with the petitioners, my lord. Because the fact.
No, the problem arose because you didn't go to the anomaly committee.
We had actually, we had submitted it. If we have a look at the affidavit, my lord.
Your affidavit says contrary to the finance. Finance say that we have asked them only to come up with this thing, with the, whether giving them at 13,300 would have any impact on the other or what you call a spiraling effect upon the others.
My lord, kindly have a look at the paragraph.
Whereas your thing is finance department was ready to give them as a supernumerary post. Isn't that your stand in your affidavit? Let's see. The response number 1, you categorically say that. Kindly come to page 77.
Yes, on the paragraph 5. It will be the second paragraph on which, my lord. That will be more relevant.
Yes.
Para 5, para 6, para 5 and para 7, madam.
Yes.
May I read, madam?
Yes.
I'm reading this from the second paragraph, madam. As per rule 5.4, actually wrongly typed as D, it's supposed to be 5.4, madam. Of the Assam Panchayat Rural Development Officers Service Rules 2013, recruitment to 100% strength of deputy CEOs, Jila Parishad shall be by promotion. Rule 11.1D further elaborates the mode of recruitment by promotion of 100% of strength of cadre of deputy CEOs to be filled up by the BDO who have experience of minimum 10 years continuous service in the cadre. Thereafter, we say, madam, a file of for enhancement of grade pay of deputy CEOs of from rupees 12,700 to 13,300 is also being processed at the department. Department time and again had requested the finance department for their concurrence in the matter. But the finance department in their endorsement dated 12/4/2021 had advised the department to resubmit the proposal subject to the department foundation undertaking, wherein the department shall agree to finance department's proposal of merging the present post of deputy CEOs with the cadre of BDO in the same grade pay of 5,400 revised to rupees 12,700. After
Now, this is what you are saying after the retirement of the present incumbents.
this is what the finance has actually recommended.
But the finance has not. Where is it? Finance says, no, we have not done that. We have only asked them that what will be the spiring effect if we give 13,300? Because there will be other officers who would be asking for more, because then again, they also understand.
May kindly have a look at the last order passed prior to the last date, my lord. Therein, the finance department was asked actually to submit the grade pay of the order passed prior to the last date. That was dated. Because as far as this particular question is concerned, this question was addressed, my lord. And thereafter the finance department was directed in the order dated, while order 11/5/2023. The last way it says, taking into account the same, this code directs the finance department to produce the pay scale so recommended by the Assam Services ROP rules.
That is what he got it. And from reading this, along with the rules, it reveals that the person who were getting the PB3 have now been given PB4, and the PB4 who was given remains stagnant with PB4.
You mean stagnant?
PB4. You see, therefore I was showing it to you. If you see page 45 of the writ petition,
Yes, sir.
see the block development officer, 8,000 to 35,000. You got it?
Yes, sir.
With grade pay of 4,700.
Yes.
Okay. Now, do you have a copy of this?
No, I don't have.
Mr. Borpujari, kindly give him a copy, although he may be your adversary for the present. Yes. Kindly come to page 278. See, this is PB3.
Yes, ma'am.
8,000 to 35,000, 4,700. Now compare it with there at page 45, it is PB3. Okay. Now, if you come just on one step up, you will find at page 45 that it is the deputy CEO who is being given the scale of 12,000 to 40,000 with grade scale of 5,400. So that is PB4. Now for the PB4 which are here, you have in that page, you have the subdivisional planning officer who has the grade pay of the similar nature. You see this? Okay. Now you see further, I will show you another aspect. Kindly come to page 283 of that document. 283. Yes. This is the senior block development officer. He also gets 12,000 to 40,000 with 5,400, which is the corresponding rank in respect of the deputy CEO.
Ranking is concerned, we'll have to go by the rules. The rules clearly state actually who is in what position. Schedule 2 clearly gives a clarity of that. BDO, after comes the CEO.
That is why I'm saying, I hope you are understanding. The senior development officer, block development officer,
Yes, ma'am.
you don't have as per these things, you don't have that.
But the fact of the matter is that he's still a BDO, man.
Who?
Maybe a senior BDO, but he's a BDO. He's not a CEO.
Whatever may be. Now let us see the recommendations which have been given by the pay commission. That what you do, you amalgamate or merge both at a later stage. But whatever, but then it came out that service rules needs to be taken note of for that purpose. But the senior BDO was getting the pay scale of PB4
Yes, ma'am.
with a corresponding grade pay of 5,400.
Yes.
And the block development officer was getting PB3 with a corresponding grade pay of 4,700. Now, by this recommendation, which is here, which have been given to the BDO, they have been brought within the ambit of PB4.
Well, actually, I've come to actually have a look at the documents right now. I haven't been actually over the documents right now.
That is why I am explaining it to you.
And as far as the senior block development officer, whether it's PB, this is actually a recommendation by the finance department. Whether this is accepted by the Panchayat Rural Development, that is a different thing altogether. I need to actually have instruction on that.
Don't go into this aspect of instruction. This is the Directorate of Rural Development. But here there is no senior BDO.
Exactly. That's what
In
I
this,
Schedule two
that is why I found out there is
There
no
is no
senior.
schedule, there is
Director
no-
of Panchayat, it is not.
There is-
But you come within Director of Panchayat and Rural Development.
We are actually the Department of the Government.
And the rules are for what? what
These
are the
rules Actually
rules?
for employees of the PNRD department.
What is that PNRD?
Panchayat Rural Development.
So rural comes in.
Actually, certain designations do not come in, but these come in, Malik. These would come in. These designations do come in,
But in these rules, there is no senior BDO. Although
Exactly.
it applies for the rural development.
that's what I was actually trying to.
So it may be that they must have thought about this thing.
Because the covering letter that comes actually, it comes with a subheading, actually with the content of the letter says that with reference to the above, I am directed to furnish share with ASROP rules in respect to the entire Panchayat rules development in favor of your necessary action.
You see, this is for Panchayat and rural development officers. So these rules do not conceive of a senior BDO.
The rules do not actually have that category.
They don't. But this ROP says about some senior BDO. But the immediate promotional post from BDO is the senior BDO.
Deputy CEO.
Understood. But you can mean it is the question of what is there in the name. The rose is always a rose.
We've actually also
So
stated this fact
let's
in the
not go
affidavit.
into
Why
that.
the affidavit stated this fact?
Huh?
We stated this fact also by the affidavit. So actually, I have no doubt about that. My lord will have a look at para 5 of affidavit. Madam. We made a clear-cut statement on this, madam. In the second paragraph.
But tell me how to resolve the situation. The petitioner is entitled, there is no doubt.
Exactly.
He is entitled.
They are
But how
senior
do
to
I
the
resolve the
CEOs,
situation?
madam. How can they have the same pay?
Absolutely. So that cannot happen.
That's why
It
we
is a
support the case,
promotional
madam. We
post.
support the.
It's a promotional post.
Yes, exactly. 100%.
Even if a person who is working for 10 years as a BDO will be entitled to a MSCP of 10 years?
Yes, sir.
Because we have 10, 20, 30.
Minimum 10 years he should be. And
So 10, 20 and 30. So what is the next scale he is entitled? Let us assume that.
after deputy CEO, madam.
No, after the BDO.
After BDO, he comes to this one, madam, deputy CEO.
Understood. But let us assume, therefore, it takes 10 years for a BDO to become a deputy CEO. Now, what is the MSCP he is going to get? He goes on the basis of the next higher grade pay.
I'll need to find that out, madam.
What you are lying to that? Don't you feel sad or sorry for Mr. Barbara out here?
We actually.
You have been
make a-
troubled
we
right,
support
left
them,
and
yes,
center,
madam.
asking him to sit
Actually,
at.
we had no hassle in providing what actually was
Right.
suggested by them. In fact,
Mr.
we
Barbara
actually,
will later on say, what is happening? I've been asked to sit after 5:30.
Madam,
Then
by the-
also the matter is not
by
happening.
para 4 of our affidavit, we stated, madam, that the proposal finance of the grade pay of the deputy CEO has been submitted to the finance table. We actually done whatever was required. Because we
You
felt
are
it was
doing,
justified
because the
claim.
main problem he is saying is, you didn't approach the anomaly committee. Did you approach?
We had. madam.
You have only submitted representation. See the finance department affidavit. Kindly see. What do they say? Categorical stand, huh?
We resume at 2, madam.
Oh, yes.
The last page of the affidavit, madam, that government file notice at page 101, running page 101. The endorsement, my lord, in the government file.
Hmm.
There, 101, possible fine just in the middle.
Yeah. Page 99. However, if the recommendation here why an anomaly department ought to have placed the matter before the, but it did not. Then now you are saying you have. I'm coming. at 2. Anything more? So that I can dictate the judgment. Your voice is not coming, something is wrong. Yeah.
One decision, lordship definitely will not like it and reprimand me.
Well,
Pertains to our own High Court, my lord.
hmm.
Reported in the Monopatra, I have checked it out.
What does it say?
It says, my lord, in view of the conflicting claim by two different departments of the government of Assam, I am of the considered opinion that the matter is required to be resolved by the government of Assam upon hearing both the departments and other authorities of the related departments whose views might be required to be taken to resolve the issue. Accordingly, the matter is sent to the Chief Secretary Government of Assam, who in turn may conclusively decide the issue upon hearing all the authorities towards resolving the dispute. Let the dispute be resolved by passing a speaking order and as expeditiously as possible, preferably within 4 months. This is, my lord, judgment and order, my lord, dated 27/5/2011, passed in WPC 3087 of 2010. Subansiri Koibotta Mean Palan, Commissioner and Secretary, Forest Department.
No, it's okay.
Yeah. I am referring to my lord.
No, Mr. Pujari, this court is otherwise also not fixing the grade pay. That is absolutely within the year, but you have to do something because you have You see, the problem why arose, it is not because of the problem of them or anybody. The problem arose because of you.
Yes.
The reason is you were in haste in giving the benefit to the video. That problem, if you wouldn't have done it, you should have waited for the service rules to be amended. If that was done, then there was no problem at all. You increased it. Thereby, the promotional persons has to be either done something to that effect. There could have been some merger of the cadre or done something to that effect. Those could have been done. But unless the service rules were not amended, you shouldn't have done that. There the problem arises.
We are bound.
Now, if you see Mewaram, there also it has been categorically mentioned to that effect. Not only that, that other one, no, which has the similar name with our leader of the opposition, some Rao. What is that name? 2015. You have given this, na? That was the case of those teachers of entry grade and not teachers. Grade. These people were asking entry grade, grade A and grade B. Now, entry grade A were higher secondary pass and they could get it. The promotional post was after 6 years to get to entry grade B. Now they were saying that, look here, we are graduates now. We are performing the same work, you give it to us. The Supreme Court said, no, nothing doing. This is, you require 6 years from entering grade A to grade B. And as such, it is a promotional post. Under such circumstances, you cannot get there. The same. Now, applying the same logic out here means that a promotional post has to have a higher grade. That is why my specific question to him was, what do you do with an MACP of 10 years, 20 years, and 30 years? For block development officer, an MACP would be 10 years.
Yes.
And at 10 years, a person would have the right to be appointed out there in or to be taken for consideration for appointment to the deputy CEO.
Yes, by the rules.
Absolutely. Now, if that be so, if a person gets to the deputy CEO, which is a promotional post, and if he gets the MACP, would he be entitled to a higher pay? No, because that is the mandate. Then why he would not be otherwise entitled to the MACP, the higher grade after completing 10 years?
That is one way of looking into the matter.
That is the only way.
Master.
The entire problem happened because of you. You shouldn't have issued that notification. Now this court can't do anything with that notification. So I have to refer it now. Therefore, this court is going to refer, but however, no hearing business. Huh?
Yes, no,
No hearing business out there. I'm going to refer it. You are to fix it, do something so that they get, you give it 13,100, 200. That is absolutely your domain to do so. But you can't have the same scale for both.
Yes.
It would have it will be violative of Article 14.
Then, yes, that will call for amendment of ROP. Amendment of ROP, modification of ROP.
That can be done. You can very well do, because the ROP only said out there that you merge the BDO with the deputy CEO. And then those people who are in the Jila Parishad, give them either in the name of deputy CEO, whatever maybe, whatever name you give it. But they will be entitled to the same scale with the BDO, which is there in the other parishads or something to that.
And both the posts have to be merged as permanent recommendation of the.
So you may take a decision that these are supernumerary posts for these people, so that after that there shall be no promotion. That is absolutely within your wisdom to do. I'm not on touching on that. But they, being on the promotional post, they cannot have the same.
We cannot turn the clock back, but at least for prospective appointments and everything, let the pay commission report prevails.
I'm not going to say that, because that is not their case. You are at liberty.
Lordship
Wisdom,
Lordship will give me some hand.
wisdom is there.
Lordship will not leave anything, my lord, open, my lord, let it, my lord.
Living and everything opening is very good for you.
Again, my lord, some,
But I am telling you,
because they are right, my lord, I agree that
being a pension judge,
Lordship will not say that.
I am having a big problem after thinking and thinking as regards the master roll worker, a person who qualifies 20 years, not confirmed, is entitled to the old pension scheme, the benefits. But a person who is otherwise confirmed, he is not, because you can't apply that.
Yes.
And if he is confirmed after 1/2/2005, he is not.
Definitely, he
He's
is
not.
beyond the cutoff date.
So when you take a definitive action out there, you are in fact spoiling, or you are saying that a person who gets a confirmation would not be entitled to certain benefits. Because obviously that particular person, in view of that office memorandum, he cannot come within the NPS, taking into account that it is not in a pensionable post. So you need to do something, being the finance.
Pension, my lord, the amendment of pension rules, my lord, is not within the domain of the department, my lord, it has to be.
Then you should not fight.
Personal.
Then you should never fight out there and say that this person is not entitled to pension or that much. Because of you, all these things are happening.
We are going by the law laid down and the rules, my lord.
Understood, but are you not creating that? If you see that judgment in Uday Pratap Thakur, this makes it further clear that a person concerned who is regularly appointed, his service can only be taken from the date of his regular appointment, or from properly after following the due process, he is being appointed. But if you are taking a person who has been subsequently regularized in terms with some scheme and giving it the entire benefit from the date of his appointment, it would hurt Article 14. Now, on the same analogy, if you look into it, a person who is concerned, who is otherwise not confirmed, you are giving the old pension rules.
Yeah, to that extent, my lord, that office memorandum may have to be revisited. Because their office memorandum only takes into account the length of service.
Because that was of 2003.
Absolutely.
And following 96.
Absolutely.
But the rules have changed.
Rules have changed.
But you are still giving the benefit.
In between, Umadevi has come, Jitendra Koleta is there, my lord, Upendas is there.
So
everything is there.
So you need to think about
that OM needs to be revisited.
it. Has to.
It has to.
Otherwise,
yes.
You are going to, because at a later point of time,
yes.
till now it has not happened.
Yes.
You know, the lawyers are very clever and they will take it up on this issue. This is a very vital issue, which till now I have not got it.
No, time and again, my lord, we are coming because that there's lesser of cases. Now they have started relying on the 2003 my lord, OM.
That is why they want 2003. Because the 2003, Sanjita Roy helps them more.
Yeah, absolutely.
Than to take the recourse to 108.
Yes.
And that is the reason why on that day I passed an order following Uday Pratap Singh and asking them to give the regularization.
Yes. Uday Pratap Thakur is absolutely clear that regularization has to be the benchmark. Nothing doing, nothing more, nothing less.
So once you have a regularization, but you don't have that minimum period of service, you can take the earlier period, but only for the purpose of calculating the qualifying service.
Absolutely. But here it gives a free go by. It gives a free, free right, direct right under that OM. Irrespective of everything, you complete 20 years of service, you get it. That OM needs to be revisited.
But Mr. A.C. Borbora, the learned I'm delivering the judgment in your favor.
Only few things, my lord. He cited just to assist the court, my lord, so that it assists my lord in Lordship observations and what type of a relief in this fact time your lordship ultimate for that 5 minutes. One of the judgment they cited about teachers and music teacher. 2000
No, not necessary.
Well,
Not
you-
necessary. That judgment is not relevant.
There is a word mechanical. It is not a case of pay parity, ours is a case of pay disparity. That is number one. Number two, my lord, the rules 2013 is somehow loop-sided. I submit, my lord, it is badly drafted rules. It ignored many things, my lord, left many areas hazy. For example, the post of CEO and etc. And apart from the confusion about CEOs also, my lord, during the lunchtime that one of my colleagues handed over me a document which my lord, both the pay commission and my lord fan house has also ignored, my lord, the senior BDO, grade 1 and SES officers. Let me have a look at that.
Government of Assam is free to merge the post of senior BDO created with the post of none with immediate. On the merger of the above post, the existing post of senior BDO and top. However, the senior BDO officer from APS class in
In 2004, it was there.
But now also they have this senior BDO.
Senior video, it is
In
2004.
rural development they have.
It is said, my lord, about the SES officers and others, their things will be different. Anyway,
No, no. Mr. Barbara, I'm going to give you a similar relief to this extent only. Yes.
I leave it. Only thing, the problem with the pay commission and the minor finance department, the executive wings, they normally follow that our rights, my lord, flow from the Constitution, Article 40. But I give a very small example, my lord, if I am not wasting time. Section 57 of the CRPC mandates that a person arrested should be produced within 24 hours, 40 minutes. That everybody knows, the executive knows, right from the police sub-inspector to the DG police knows. But what they perhaps, these executive wings ignore, that this production within 24 hours, I learned it, flows basically from Article 22 of the Constitution. Let me have a look at Article 22 of the Constitution, my lord. I am still in the learning process, my lord. Can you say Article 22? 2.
Yeah. Yes.
So executives and my lord, whether it is police or my lord, the appointing authorities of various departments, they ignore the constitutional rights of my lord, a section of the employees or this while dealing with my lord, determination of pay or everything. The right actually flows from the Constitution. That is basically our case. Then, my lord, therefore, as lastly, I submit that we have also impugned the pay commission's recommendation. Somehow, government gave a rider that it will be subject to the service rules, good or bad. And apart from other, my lord, confusion with regard to service rules, there is no confusion about the hierarchy that we have been promoted. That was the first promotion in our life, my lord. We have joined in 1988, 2016 for the first time we were promoted to deputy CEO. Now, my lord, the question is now I'll come to the prayer portion. The entire, my lord, action of putting the grade pay at the same level is therefore unconstitutional. And for that, I have shown, my lord, this is an unreasonable classification. Unreasonable classification. Now, my lord, lordship, under the circumstances, what type of, my lord, reliefs that your lordship can mold and give directions, my lord, I read the prayer portion of my lord, because 5 of us are already retired, as I said. 5 of us. Page 25, my lord, my prayer. Page 25, my lord,
but the prayer number 2 is very difficult.
that is difficult. I agree. Unless there is a rule, my lord, and we have now notionally promoted from last year during pendency. I am not on that, my lord. Lordship will leave it. He give you an observation about it. Direction to grant, my lord, when the release the area difference of the grade pay. The area difference of the grade pay with effect from the date when the PGOs were given the grade pay. Higher grade pay.
No, that I remember.
That is one link, and secondly, my lord, and the pension calculation, we have already been started to be paid pension, my lord, taking, my lord, 12,700 as the pay into account. My lord, that will have to be, my lord, that is the another, my lord, direction that your lordship may give, my lord, notionally on that day. And there also we may be entitled to get the area difference of, my lord, pensionary benefits. Some retired last year, some retired this April, this January, like that. Then one more thing, I, my lord, pray, take your lordship to paragraph, my lord, the deputy CEOs, paragraph 11 of page 16 of the writ petition, my lord.
13,904.
Yes.
The petitioner says that PRD rules 13 clearly show that the post of deputy chief executive officer is immediately higher in hierarchy to the post of assistant development commissioner. Lordship has again see the, my lord, hierarchy at page, my lord, 36. There is a post in between block development officer and deputy CEO. There is a post in between which has been assigned to fishery department, my lord, assistant development commission. The assistant, it is pertinent to mention here in that the post of assistant development commissioner has a present grade pay of 13,300. Therefore, our grade pay will have to be at least above that of, my lord, 13,300 assistant development commission.
But if we go by the schedule, page 45.
Yes, yes. Yes.
Your
are in the
grade
payment
pay
for.
was 5,400.
Yes.
And
Payment
the
for, my lord.
assistant development commissioner was grade pay was 5,900.
Here, my lord, actually, but the hierarchy wise, as per, my lord, the rules, section 3, kindly see where the assistant development commissioner lies.
Understood, but that is there. But here it is categorically shown how it will be there.
There is a contradiction. But for the hierarchy, we'll have to go to schedule 2, my lord.
That is what.
So that is what I am pointing out, my lord. Here, my lord, lordship will find here, page 46 also, below for block division, then thereafter on top.
The assistant development commissioner is above you at number 8, and the deputy chief executive officer is 10.
As per this, but as per, my lord, page 36, kindly see. As per page 36, there is some contradiction. Page 36, the hierarchy, my lord, as laid down by the rules themselves.
Understood, but the
It is
assistant
a-
development commissioner, if you see out here at rule number
In between,
E.
Deputy CEO is above them and block development officer below.
No, they have put it in such a manner. Just for example, here, if you see, kindly see here at page 37.
Lordship. Lordship.
They have done it as per them. You see, at number 4, recruitment of 100% strength from so and so from
Shall be made by promotion.
shall be by promotion.
Promotion from BDO.
100% shall be from promotion.
Promotion from
Yes.
BDO, obviously.
Yeah. Now, here for the purpose of this particular assistant development commissioner, it can't be, it has to be from extension officers fisheries.
Yes, that is in page 39.
Yes.
E,
Yes.
100%.
So here the block development officer is not there
Not yet.
for fisheries.
Not yet.
And this is only for Assistant Development Commissioner, is only for fisheries.
And the hierarchy shows it. So, my lord, my prayer therefore coming to
So-
the prayer.
So, Mr. Barbara,
Yes.
you take your seat, let me dictate.
There-
Anything
that's
else, I will put it in
That's
cooperate.
fine, lord,
Yes.
it can mold it.
There's
Yes.
one more thing, Malad, I would like to point out.
Uh,
I have a noting, Malad, it says the noting, as per the noting dated 25/1/2021, it says that the post of senior BDO has already been abolished and merged with the post
That
of
is what
BDO.
is there on 11th of August 2004. It has been abolished. That is the notification that Mr. Barbara has placed. Heard Mr. AC Barbara, yes.
Since they are asking, my lord, the payer person, they are seeking, my lord, their scale of pay, my lord, grade pay to rupees 13,900.
Mr. Kindly listen. I passed the order,
My
listen
lord,
to
my lord,
this.
because there are contradictions in the service rule itself. that much.
No, it is not required. Take your seat.
My lord, today assisted by my lord, MS Noor Begum, my lord, retired principal of the girls' college here, my lord,
Okay.
20th part.
Right.
Today I am assisted.
And I heard Mr. S.C. Barbara, the learned senior counsel, assisted by Swenso, the learned counsel appearing on behalf of the petitioners. Mr. Arbor Pujari, the learned counsel appeared on behalf of the finance department. Mr. N.K. Devnath, the learned counsel appearing on behalf of the Panchayat and Rural Development Department. And Mr. C.K. C.S. Hazarika appearing on behalf of the personnel department. The issue involved in the instant writ petition is to whether there has been a disparity in the pay of the petitioners who are working in the cadre of Deputy Chief Executive Officer, in as much as, which is the promotional post from the post of the Block Development Officer, in as much as the scale of pay, the grade pays, the scale of pay is also same, na?
Great pace, say.
What is your grade pay now? What is your scale of pay now?
Presently, my lord, we are getting, it is in the recommendation.
It will be from 30,000 to 110,000 only.
Yes, ma'am.
Scale of pay as well as the grade of pay is one and the same.
Yes.
Because ROP does not specify deputy CEO, that's what.
That is old.
That I am not till now, we have reached now.
That is old. That is old. My lord, payment for.
It appears from the records, the facts involved in the instant case are that the petitioners herein were appointed as block development officers on various dates Full stop. The petitioners were thereupon promoted to the post of Deputy Chief Executive Officer on 29/2/2016 and 26/6/2019. By the promotional orders as enclosed as Annexure 1 series to the instant writ petition. On 23rd of February 2021, the governor of Assam, in exercise of the powers conferred under the proviso to Article 309 of the Constitution, amended the schedule to the Assam Service ROP Rules 2017, whereby the block development officer was given a revised pay structure with the pay band of rupees, with pay band 4, in pay band 4 of rupees 30,000 to 1,10,000, and gave pay of rupees 12,700. It is the case of the petitioners herein that as the post of the petitioner, as the post held by the petitioners are promotional posts from the post of the block development officer, the post of the deputy CEO cannot have equal pay, cannot have the equal grade pay with that of the block development officer. Various representations were submitted, but nothing constructive happened, for which the present petition has been filed. It appears on record that although that this court, by an order dated 23/8/2021, issued notice making it returnable on 8/11/2021. Further to that, this court on 18/1/2023 had admitted the instant petition by issuing a rule. It appears on record that on 31/5/2022, the Joint Secretary to the Government of Assam Panchayat and Rural Development of Department filed an affidavit, the details of which this court shall deal at a later portion of the instant judgment. But it appears therefrom that the Panchayat and Rural Development Department had supported the case of the petitioner insofar as the disparity of the pay it further appears that the respondent number 3, that is the Finance Department, had also filed an affidavit in opposition on 13th of September 2022. A gist of the said affidavit in opposition reveals that the government of Assam had duly accepted the report of the Pay Commission and it is in consequence to that wherein there was a recommendation of merger of the post of the Deputy CEO with the post of the Block Development Officer. The revised structure of pay was given to the block development officers by the notification dated 21/2/2021. 21, na?
23/2/2021.
23/2/2021. In the backdrop of the above, let this court therefore consider the respective submissions of the learned counsels for the parties. Mr. A.C. Barbara, the learned senior counsel. During the course of his arguments, have drawn the attention of this court to the Assam Panchayat and Rural Development Officers Service Rules 2013, for short, the rules of 2013, which were made by the Governor of Assam in exercise of the powers under the proviso to Article 309 of the Constitution. The learned senior counsel referred to clause 3, rule 3 of the rules of 2013 and drew the attention of this court that rule 3(1)(d) refers to the post of Deputy Chief Executive Officer, Jilla Parishad. And rule 3(1)(f) refers to Block Development Officer, Principal, Gaon Panchayat Secretary Training Center. Referring to rules 5 of the rules of 2013, which stipulates the method of recruitment, the learned senior counsels submitted that rule 5(4) mandates that the recruitment to 100% strength of the Deputy Chief Executive Officer, Jilla Parishad, shall be made by promotion. Whereas, in respect to However, whereas in Rule 5.6, the recruitment to the post of block development officers shall be made A, 40% by direct recruitment through the commission, and B, 60% by promotion from the officers in the cadre of extension officer credit. Credit is bracket. Extension officer panchayat and extension officer women and children at the ratio of 20% each equally. Further referring to Rule 11, which relates to recruitment by promotion, the Learned Senior Counsel drew the attention of this court to Rule 11D, which stipulates that 100% of the strength of the cadre of Deputy Chief Executive Officer shall be filled up by the block development officer who have experience of 10 years, minimum 10 years, continuous service in the cadre. Reference was also made to Rule 11F as to how the 60% of the strength of the cadre of block development officer shall be filled up. It was therefore the submission of the Learned Counsel for the Senior Counsel for the petitioner that from a conjoined reading of the rules, it would categorically show that the post of the Deputy CEO is a promotional post from the cadre of block development officer. That too, after completion of a minimum period of 10 years. The Learned Senior Counsel further drew the attention of this court to Rule 4, Rule 4, Rule. Rule 23, Rule 23 of the rules which relates to pay. A perusal of Rule 23 shows that all appointments in the service shall be made in the time scale of pay as may be prescribed by the government from time to time. The scale of pay of the post in the cadre of the service on the date of commencement of the rules have been shown in Schedule 1, Roman 1. The Learned Senior Counsel, on the basis of Rule 23, further drew the attention to Schedule 1, wherein it shows, it is seen at serial number 10, the post of the Deputy Chief Executive Officer, Jila Parishad, have been shown in the scale of pay of rupees 12,000, there's 40,000 with grade pay of rupees 5,400. And in serial number 11, the cadre of block development officer have been shown with the scale of pay of 8,000 to 35,000 with grade poor of rupees 4,700. The learned senior counsel further submitted that from schedule 1 it is apparent that the post in the cadre of Deputy Chief Engineer Executive enjoys the pay scale in PB4, whereas the post in the cadre of Block Development Officer enjoys the pay scale in PB3. The learned senior counsel further, referring to Rule 8, and Schedule 2 of the rules of 2013, further drew the attention of this court to serial number 10 and serial number 11, wherein the post of the Deputy Chief Executive Officer, Jilla Parishad, and Block Development Officer, Jilla Parishad, have been duly, respectively, have been mentioned. The learned senior counsel, during the course of hearing, further drew attention of this court to a notification dated 11th of August 2004, issued by the Commissioner and Secretary to the Government of Assam Panchayat and Rural Development Department, whereby the Governor of Assam merged the post of Senior Block Development Officer, created by Government Letter Number RDD.144/04/14 dated 27/6/2000.86 and number RDD.144/4/16 dated 26/9/2000.86 with the post of the Block Development Officer with immediate effect. The learned senior counsel, while drawing their attention to the said notification, further submitted that the perusal of the notifications would also show that those senior block development officer even after the merger and designated as the block development officer have been granted the pay protection the said document which was as the said document was placed during the course of the hearing, the same is kept on record and marked with the letter X. Next. The learned senior counsel submitted that all the problems arose in view of the recommendations so made by the Assam Pay Commission, whereby by the seventh Assam Pay and Productivity Pay Commission. At para 1.23, it was recommended that para 1.23 and more particularly at serial number 5, at clause number 5, it was recommended that the promotion from Group B should be made to the level of BDO in the grade pay of rupees 5,400. In serial number 8, it was recommended that the post of the Deputy CEO BDO senior grade and the BDO shall be put in the same pay scale with grade pay of rupees 5,400. It was recommended that the designation of the BDO senior grade be abolished and the officers posted in the Jila Parishad be called the Deputy CEO and those posted in the blocks be called BDO, both having the same grade pay of rupees 5,400. It was further recommended that as a consequence of this, such recommendations, the extension officer Group B can be posted on promotion either as Deputy CEO or BDO. Clause 8. The Lalit Senior Council submitted that though these recommendations were made by the Assam Pay Commission, the 7th Assam Pay Commission, but the same could not have been acted upon unless and until the service rules were amended. The Lalit Senior Council further drew the attention to the Assam Gazette Extraordinary dated 17th of March 2017, wherein this is by the Anomaly Committee.
No, my lord. Government took my lord, the report of the Pay Commission by making it specific that the provisions of service rules shall apply in the report. Page 51.
No, that I've seen it, but who has done this?
The government has done.
This is.
Government make it. Paragraph 8 of your recommendation, paragraph 7 of your recommendation. Page 51, my lord, is the relevant action.
Yes. Last time too. 17, whereby who has issued this gazette? Page 52, 53, who has issued this gazette? Personnel Department.
Yes.
Yes, Mr. Hazarika. You want that your name has not be CK but CS, but who has issued this? This particular document, page 52.
Sir, whole series. Here you will find. At page 53, man.
52, 53, that is, who has issued this gazette?
Definitely by the Malad Panchayat.
No, it can't be Panchayat, it contains everything, all departments.
Page 53D.
Report your lordship.
Page 53D, my lord.
52, 51, 52.
52?
51, 52, 53, these are all continuing numbers.
Huh?
And it's a 4 series, these are all continuation, your lordship.
Understood, but who has issued this?
Pay and productivity, finance of it. This is a report, your lordship.
This is a gazette.
Page 53.
Relevant aspect of the report of the 7 Assam Pay and Productivity Commission.
No, this is gazetted. Who has done it?
Definitely Malad Panchayat.
No, it can't be Panchayat because it also has, you see at page 52, Agriculture Department also, it can't be.
It will have to be by the personnel department.
That is what I'm saying, whether it is by the personal department.
Page 53D. Page 53D. The provisions of service rules shall apply to the recommendation.
That I've seen it, 17.
Definitely. Has to be by the personnel.
My understanding is that all of this is the extract of the report of the 7 Finance Commission. So it will not be personal department. Your lordship.
Got it.
It will be by finance PRU department.
That is what I got it.
That my lord will find at page 54. It has a mention of that my lord Assam Gazette 17 March 2017.
That is what I said, na? Last time too. Further, drew the attention to the notification dated 17th of March 2017 issued by the additional chief secretary to the government of Assam Finance Department in the name of the governor. In clause 2039, Roman 22. D. It was mentioned that the provisions of the service rules shall apply in the recommendations of the commissions at subpara 4, 5, 7, and 8 of para 1.23. It is therefore the submission of the learned senior counsel that unless and until the service rule is amended, the recommendation in terms with para 1.23, recommendations in respect to men made in clause 8 of para 1.23 cannot be given effect to. The learned senior counsel submitted that without there being an amendment made to the service rules, the finance department, the finance department of the government of Assam, in exercise of the powers under the proviso to Article 309 of the Constitution in the name of the governor, gave effect to clause 5 of para 1.23, thereby revising the pay structure insofar as the BDO is concerned. Footstop. And accordingly, by the said notification, the grade pay of the BDOs were increased, were revised to 12,700. It is under such circumstances a disparity occurred whereby a promotional post as per the rules of 2013, promotional post in the cadre of Deputy CEO in terms with the rules of 2013 have been given the same pay, same grade pay as that of the entry level post of the BDO. It is under such circumstances the learned senior counsel submitted that the petitioners had filed representations and the responding authorities having not acted on the same, the present writ petition has been filed seeking interference by issuance of a writ of mandamus directing the concerned respondent authorities that a grade pay for the post of the Deputy Chief Executive Engineer Officer under the Panchayat and Rural Development Department should be 13,900 with effect from the date on which the block development officer have been given enhanced pay of grade pay with all consequential benefits. The learned senior counsel further drew the attention of this court to the affidavit filed by the respondent number 1 and 2, wherein also the Panchayat and Rural Development Department had supported and endorsed the view, had supported the stand of the petitioner and had requested the finance department to retain the post of the deputy CEO and to enhance the grade pay of the deputy CEO to rupees 13,300. Referring to the affidavit so filed by the respondent number 3, the learned senior counsel submitted that the finance department, after having enhanced the grade pay of the block development officers, that too without the service rule having been amended, cannot take the plea that if there is an interference to the action of the said respondents, it would affect cannot take the plea, that no interference should be made on the ground that an expert body had made recommendations. The learned senior counsel further submitted that the plea so taken that in absence of specific recommendation of the 7th Pay Commission, the government in the finance PRU department is not in a position to upgrade the pay scale of the deputy CEO cannot be an absolute proposition of law. Well, by the actions of the finance department, it has resulted in a disparity in pay, whereby the promotional post as well as the entry-level post have been given the same pay. That too, when the line department have categorically expressed their opinion that the that the post of deputy CEO carries higher responsibilities and work. Anything else?
This is irrational and absurd.
Huh?
Irrational and absurd. Both take on. I think lordship is taking a break.
The learned senior counsel, therefore, drawing the attention of this court, drew the attention of this court to various judgments of the Supreme Court in the case of number 1, Mewar Ram Kanojia versus Assam in All India Institute of Medical Science and others, reported in 1989 2 SCC 235. Shyam Babu Verma and others versus Union of India, reported in 1994 2 SCC 521. Union of India versus TVLN Mallikarjuna Rao, reported in 2015 3 SCC 653. And the Uttar Pradesh Power Corporation Limited versus Ayodhya Prasad Mishra and another, reported in 2008 10 SCC 139. I'm coming in 5 minutes. Huh? The posts were redesignated as Deputy Chief Executive Officer in the Jilla Parishad by order dated 19/8/2004. Referring to Rule 5B of the rules of 2013, as well as Rule 11(1)D, the Learned Counsel submitted that the post of the Deputy CEO is a promotional post from the post of the Block Development Officer, who has to have an experience of minimum 10 years continuous service in the said cadre. The Learned Counsel submitted that pursuant to the notification issued on 23/2/2021 by the Finance Department, whereby the grade pay was made equivalent, whereby the grade pay of the block developed BDOs were made equivalent to the grade pay of the Deputy CEO, a proposal was sent to the Finance Department for enhancement of the grade pay of the Deputy CEO from 12,700 to 13,300. However, the Finance Department in its endorsement dated 12/4/2021 directed the PNRD department to resubmit the proposal subject to the department furnishing an undertaking, wherein the department shall agree to the Finance Department's proposal of merging the present post of Deputy CEO with the cadre of BDO in the same grade pay of 5,400, revised rupees 12,700 after the retirement of the present incumbents holding the post. The Standing Council further submitted that the abolition of the post of the Deputy CEO by merging the same with the post of the BDO would create substantial difficulties for functioning of the system. And would also hamper the promotional aspects of the serving BDOs. The Learned Standing Council further submitted that the PNRD department had again expressed its views that the grade pay of the Deputy CEO should be enhanced from 12,700 to 13,300. And the said aspect of the matter is presently pending in the finance department. Mr. Arbor Pujari, the Learned Counsel appearing on behalf of the finance department, on the other hand, submitted that the 7th Pay Commission, Assam Pay Commission, had recommended at para 1.23 bracket 8 that the post of the Deputy CEO, BDO senior grade and BDO shall all be put in the same grade pay scale with grade pay of rupees 5,400. The designation of the BDO brackets senior grade was to be abolished, and the officers posted in the Jilla Parishad should be called the Deputy CEO, and those posted in the blocks should be called the BDO, both having the same grade pay of rupees 5,400, corresponding to the revised grade pay of rupees 12,700. On the basis of the said recommendation, the Learned Standing Council for the Finance Department submitted a proposal was received from the Panchayat and Rural Development Department for upgradation of the pay scale of the Block Development Officer BDO from the existing pay scale with grade pay of rupees 12,700 and the post of the Deputy CEO from the existing pay scale with grade pay of rupees 13,300. The said proposal was examined by the Finance PRU Department, and as per the recommendation of the 7th Pay Commission, Assam Pay Commission, the pay scale of the post of the BDO was upgraded from the existing pay scale of PBN 3 to PBN 4 by notification number. The notification dated 23/2/2021 and 1/4/2016. As regards the proposal for upgradation of the pay scale of the post of the Deputy CEO from the existing PB4 plus grade pay of rupees 12,700 to PB4 with grade pay of 13,300, there being no recommendation of the 7th Assam Pay Commission in the matter, the Finance Department requested the PNRD Department to examine and take action as per the recommendation of the 7th Pay Commission and amend the service rules if required by the endorsement dated 23/2/2021. However, the Panchayat and Rural Development Department resubmitted the proposal for upgradation of the pay scale of the Deputy CEO, stating that the post of the Deputy CEO is a promotional post from the post of the BDO and is higher in rank to the post of the BDO. The said proposal was examined again by the Finance PRU Department and by the endorsement dated 28/7/2022. The Panchayat and Rural Development Department was informed that the 7th Assam Pay Commission, after thorough in-depth study and examination, had recommended that the post of the Deputy CEO BDO, Deputy CEO, BDO senior grade and BDO should be in the same grade pay of rupees 5,400 corresponding to the revised grade pay of rupees 12,700. On receipt of this proposal from the Panchayat and Rural Development Department for upgradation of the grade pay of the BDO, and there being recommendation of the 7th Pay Commission for upgradation of the grade pay of the BDO to 5,400, corresponding to the revised grade pay of rupees 12,700, the pay scale of the BDO was enhanced by the notification dated 23/2/2021. It was further mentioned that though there was a request from amending the rules if so required, no action on amendment of the rules have taken by the Panchayat and Rural Development Department, and they have on the other hand justified the upgradation on the ground that the Deputy CEO was created as a promotional post from the BDO, due to which the recommendation of the 7th Assam Pay Commission could not be followed. And if the recommendation of the 7th Assam Pay Commission is acted upon, it would be anonymous. It was further mentioned that the PNRD department again resubmitted the proposal justifying the upgradation in view of the manifold responsibilities of the Deputy CEO, PNRD full stop. The PNRD department had also stated that there were 44 sanctioned posts of the Deputy CEO, and at present men in position is 9, and the remaining 35 posts were vacant. In view of the said, the PNRD department was again requested to clarify if there are other posts under the PNRD department with grade pay of rupees 13,300 and the possibility of those incumbents again claiming for higher pay if the grade pay of the Deputy CEO is upgraded. The PNRD department was also requested to furnish the financial implications. In support, it is therefore seen from the submissions so made by Mr. R. Borpuzari that the notification dated 23rd of February 2021 was issued, thereby enhancing the grade pay of the BDOs on the basis of the recommendation being made by the 7th Assam Pay Commission. And the reluctance of the finance department to give a higher grade pay to the promotional post of the Deputy CEO is on the ground of the recommendations so made by the 7th Assam Pay Commission for merging the post of the Deputy CEO senior BDO as well as the BDO. And also on the ground that if the grade pay of the deputy CEO is increased to rupees 13,300, there would be similar claims in respect to other cadres of the Panchayat and Rural Development Department. The learned counsel appearing on behalf of the Finance Department have relied upon two judgments. Footstep. The first of such judgment is the judgment in the case of the state of Bihar and others versus Bihar Secondary Education Struggle Committee, Munger and others, reported in 2019, 18 SCC 301, and more particularly referred to paragraph number 96 and its subparagraphs. The second judgment so referred is the judgment in the case of
That is judgment dated 27/5/2011, passed in WPC number 3087 of 2010.
Give me the name.
It is Subansiri Koibarta Mean Palan Self-Help Group.
Get a shorter name. Yes, spelling.
Subansiri, SUBANSIRI.
N-S-I-R-I. Then Subansiri Koibarta Mean.
Koibarta, KOIBOR.
It was given when?
It was delivered on 27/5/2011.
PK Sharma?
Yes.
Justice?
Yes, madam. Yes.
The second judgment so relied upon is in the case of Subansiri Koibarta Mean Palan Self-Help Group versus the Commissioner and Secretary to the Government of Assam, Forest Department, Dispur.
I'm so grateful, madam.
What is the date of the judgment?
My lord, here it is stated, my lord, 27/5/2011, 27th of May.
Reported in 2011, 6 GLR 41.
I'm relying on para 21 as per the my lord Monopatra version. It starts with the words "in view of the conflicting claim."
And referred to paragraph number 21. of the said judgment. I've heard the learned counsels for the parties and have perused the materials on record. From the facts narrated herein above, and upon a perusal of the rules of 2013, there is no dispute that the post of the Deputy CEO is a promotional post from the post of the Block Development Officer, as can be seen from Rule 5
Rule 3. Page 36.
Rule 5(4) and read with Rule 11. One D. For the purpose of the said rules, therefore shows that the post of the Deputy CEO is a promotional post from the cadre of the Block Development Officer, and it is only after an officer in the cadre of Block Development Officer having an experience of minimum 10 years continuous service, he has the qualification, eligibility for the purpose of being considered for promotion to the post of the Deputy Chief Executive Officer. Rule 12 prescribes a detailed procedure as to how the promotion is to be effected. From Rule 12(4), it would be seen that the promotion is to be effected on the principles of merit with due regard to seniority. It would also be seen from Rule 23, read with the first schedule, that the post of the Deputy Chief Executive Officer at the time of framing of the rules was put in pay when 4 with grade pay of rupees 5,400. Whereas the post of the Block Development Officer was put in grade pay of was put in pay band 3 with grade pay of 4,700. It is also seen from para 1.23, clause 5 of the recommendations so made by the Assam Pay Commission, that it was of the recommendation made by the Assam Pay Commission, that the grade pay of the block development officer should be increased to 5,400. It seems that on the basis of the said recommendation, it is also seen. Now, however, it is also seen that in clause 8 of para 1.23, it has been also mentioned that there is a requirement of reorganization of the cadre. There was a requirement, there is a recommendation for reorganization of a cadre, whereby the post of the deputy CEO, senior grade BDO, and the BDO should be amalgamated or merged. And those who are posted in the Jilla Parishad merged into the cadre of BDO, and those posted in the Jilla Parishad should be given and should be called the deputy CEO, and those posted in the blocks should be called the BDO. It is also seen that from the notification issued by the Finance Department, by the Additional Chief Secretary of the Finance Department, dated 13/3/2017,
17.3.
17/3/2017, more particularly in clause 39, Roman 22D, that the compliance in terms with clauses 4, 5,
Page 53 of the requisition.
the compliance in terms with subpara 4, 5, 7, and 8 of para 1.23. That the provisions of the service rules shall apply in the recommendations of the commission at para 4, 5, 4, 5, 7, and 8 of para 1.23. This notification is issued under what provision? It doesn't seem to be under 309.
Yes, my, no, this is not the 309 notification, my lord.
Then if it is not a 309, can it override the service rules?
No. It is in the report of the anomaly committee post the recommendation of the pay commission. It has been published in the form of a gazette.
Maybe, but this is not under 309.
No, it appears to be not.
See, have you got it? Have a look. Look at the
But page 54 of the writ petition says,
but they have not enclosed the entire thing. This is for them. This is for them. I'm not on that. But this notification is not under 309.
this is not under 309.
So this notification cannot override the service rules.
It cannot override the service rules. Service rules is 309, and the effect of this notification will be given in ROP rules, which is otherwise 309.
Maybe, but ROP rules does not consider anything about the CEO.
Exactly.
So under such circumstances,
These are government resolution on the report of the thing.
no, it is a notification.
No, it is a notification. So they have
After careful consideration of the seventh report of the Siemens and the report of the Iman, the government has accepted the recommendation of the seventh pay commission with modification as suggested by the committee and any other modification as have been deemed necessary and is pleased to decide as follows.
Yes.
So this is just a decision.
This is the decision and the effect of the decision when it is applied, my lord, under the rules of the ROP rules. Those are, my lord, ROP rules are 309 under 30 provision. That, my lord, will find at 54. Page 54 of the writ petition.
No, page 54 is only as regards video.
Absolutely, it may be with regard to video, but this is the procedure that I am submitting.
No, whatever.
Yes.
Para. The provisions of the service rules shall apply in the recommendations of the commission at subpara 4, 5, 7, and 8 of para 1.23. However, it is relevant to take note of that the said notification dated 17/3/2017 is a notification intimating all concerned that the government had accepted the recommendation of the 7th Assam Pay and Productivity Pay Commission with modifications as suggested by the committee and any other modification as have been deemed necessary and is pleased, and accordingly the said notification was made. It is, however, relevant to take note of that the service rules, that the rules of 2013 are statutory rules framed under the proviso to Article 309 of the Constitution. And by way of the notification dated 17/3/2017, the said the rules of 2013 could not have been amended. At this stage, this court finds it relevant to take note of the scope of interference under Article 226 in respect to pay parity, the learned senior counsel appearing on behalf of the petitioner had submitted various documents, various judgments, as have been already mentioned here, supra.
Unequals equals, constitutional rights violation 1416, unequals cannot be equal.
No. Various judgments. I peruse the various judgments. And from a perusal of the judgment in the case of TVLN. Mallikarjuna Rao, Supra,
Union of India versus Mallikarjuna.
would show that the earlier judgments of the Supreme Court, which have been referred to by the learned senior counsel, have been duly considered. In paragraph number 25 of the said judgment, the Supreme Court refers to the Staff Selection Commission, Electronic Data Processing Group C, Post of Data Entry Discipline, Recruitment Rules of 1996. It was observed that from the said rules, it was clear that the qualification of the data entry operator, grade A, is higher secondary, whereas the qualification of data entry operator, grade B, is graduation. And it is a promotional post from data entry operator grade A persons who have 6 years of experience. It was observed that the classification of post and determination of pay structure comes within the exclusive domain of the executive. And the court and the tribunal cannot sit in appeal over the wisdom of the executive in prescribing certain pay structure and grade in a particular service. In paragraph number 27 of the said judgment, it was observed that the government, on consideration of the report submitted by the committee, issued the office memorandum dated 11/9/1989, prescribing therein different pay scales and different grades of data entry operator, besides the mode and the manner of recruitment to and qualification for each entry grade post, as well as eligibility and experience for promotional grades. It was observed that the court or the tribunal would be exceeding its power of judicial review if it sits in appeal over the decision of the executive in the manner of prescribing the pay structure, unless it is shown to be in violation of Article 14 and 16 of the Constitution of India.
Para 30 follows Mewala.
It was further observed that the difference in pay scale based on educational qualifications, nature of jobs, responsibility, accountability, qualifications, experience, and manner of recruitment does not violate Article 14 of the Constitution. In paragraph number 28, which is pertinent for the purpose of the instant dispute, the Supreme Court categorically observed that both the tribunal and the High Court failed to notice that the data entry grade operator grade B in the pay scale of rupees 1350-2200 is a promotional grade, and only those who have 6 years of experience are eligible for such promotion. It was made categorically, it was specifically observed that a promotional grade and entry grade cannot have the same pay scale. And in absence of a declaration that the rationalization of the pay scale of electronic data processing post made by the office memorandum is illegal, benefit could have been granted. The relevant portion of the paragraph 26, 25, 26, 27, and the relevant portion of paragraph number 28 are reproduced hereunder. I got hold of one judgment, I got lost it somewhere. So many judgments. No. Turn it, please, evoke.
Is it Mewala or Manda?
No. Nevertheless, I have dealt with. It's another judgment I have. This is a very recent judgment of Justice Bella Trivedi. 2023 to SS. Got it. Next. Now coming to the judgments which have been referred to by the learned counsel appearing on behalf of the Finance Department. That is in the case of Bihar Secondary Teachers Struggle Committee, Mungar and others, wherein reference was made to paragraph number 96. You have that book? My internet is gone.
Yes.
It doesn't come.
Well,
Got it. Wait. Not necessary.
well,
Reference has been made to paragraph number 96. And its subparagraph. That is paragraph 96.6. (96.7) and 96.8. A perusal of the said paragraphs so referred to is an absolute proposition of law that granting a pay scale is a purely executive function, and hence the court should not interfere with the same, inasmuch as it may have a cascading effect, creating all kinds of problems for the government and the authorities. The proposition that the equation of post and salary is a complex matter which should be left to an expert body is not in dispute. Further, the proposition that granting of pay parity by the court may result in a cascading effect and reaction which can have adverse consequences is also an absolute proposition of law. In fact, in a recent judgment by the Supreme Court in the case of Union of India versus Indian Navy Civilian Design Officers Association and another, reported in 2023 SCC Online SC 173. The Supreme Court had also observed that the doctrine of equal pay for equal work is not an abstract doctrine and is capable of being enforced in the court of law. Comma, the equal pay must be for equal work of equal value. It was observed that the equation of post and determination of pay scales is the primary function of the executive and not the judiciary. Under such circumstances, the courts therefore should not enter upon the task of job evaluation, which is generally left to the expert bodies like the pay commissions, which undertake rigorous exercise for the job evaluation after taking into consideration several factors like the nature of the job, the duties, the accountability, and the responsibility attached to the post, the extent of the powers conferred on the persons holding a particular post, the promotional avenues, the statutory rules governing the conditions of service, the horizontal and vertical relatives with similar jobs, etc. It was further observed that the nature of work involved in two posts may sometimes appear to be more or less similar. However, if the classification of the post and the determination of the pay scale have reasonable nexus with the objective or the purpose sought to be achieved, namely the efficiency in administration, the pay commissions would be justified in recommending, and the state would be justified in prescribing different pay scale for the seemingly similar post. It was observed that the higher pay scale, to avoid stagnation or resultant frustration for lack of promotional avenues or frustration due to longer duration of promotional avenue, is also an acceptable reason for pay differentiation. In paragraph number 17 of the said judgment, the Supreme Court observed that the power of judicial review in matters involving financial implications are also very limited. The wisdom and the advisability of the courts in the matters concerning the finance are ordinarily not amenable to judicial review unless a gross case of arbitrariness or unfairness is established by the aggrieved party. Paragraph number 14 and 17 of the said judgment, being relevant, is quoted hereunder. In the backdrop of above proposition of law, as laid down by the Supreme Court in the various judgments, it is clear that the scope of judicial review is limited, since a case of arbitrariness or unfairness is established by the aggrieved party. The materials of the record in the instant case would clearly show that the post of the Deputy CEO is a promotional post from the cadre of the BDO. The Finance Department, in terms with para 1.23 Roman bracket 5, normal 5, had granted the benefit of enhancement in the grade pay of 5,400 to the BDO, corresponding to rupees 12,700. However, the rules were not amended. Nor any steps have been taken for the purpose of merger of the post of BDO, senior BDO, as well as the Deputy CEO. The notification dated 17/3/2017 under no manner can override the statutory rules of 2013. Therefore, till the said rules exist, the post of the Deputy CEO continues to be a promotional post from the cadre of the BDO. And as such, giving the same pay scale to both the entry level cadre or post, along with to the feeder post and the promotional post, would amount to gross case of arbitrariness and unfairness, and thereby violate the mandate of Article 14 of the Constitution. Accordingly, this court therefore is of the opinion that the petitioner is therefore entitled, the petitioners herein who are in the post of cadre of the Deputy CEO would be entitled to a higher grade of pay from the grade of pay, so higher grade pay than the grade pay so given to the BDO. Now the question arises as to what should be the grade pay to which the petitioners would be entitled to. In the writ petition, the petitioners have claimed the grade pay of 13,900. The PNR department have filed in the affidavit that the post of the deputy CEO should carry a grade pay of 13,300. The judgment of the Supreme Court in the case of Indian Navy Civil Engineers, Civil Design Officers Association, SUPRA, categorically mandates that it is not within the realm of the court to decide what should be the grade pay to which the petitioners would be entitled to. This court only what should be the grade pay? The petitioners, the petitioners who are in the post of the deputy CEO would be entitled to. Except that the post of the deputy CEO would be entitled to a higher grade pay than that of the post of the BDO. Accordingly, this court therefore directs the state government, whom?
Let the chief secretary take a call, my lord, in view of this decision.
Chief secretary. That is some other, some fishery or settlement. You are not there.
Yeah, then again, my lord, PNRD and finance will have to be directed. Both the departments will have to sit together because the nature of job, my lord, everything, they will have to provide the inputs.
Under such circumstances, this court therefore directs the chief secretary.
But the chief secretary, my lord, appears to be not implemented here.
No, not necessary. Mr. Hazarika is always there.
Yes, chief secretary, because he will be able to take into full, my lord, the personnel department also, because personnel department is a party as per that.
Directs the chief secretary to the government of Assam in consultation with the finance department, the PNRD department, as well as the personnel department of the government of Assam, to take a decision as to what amount, as to how much, no, as to what should be the grade pay of the in the post of the deputy CEO,
which is higher than that of video.
Barbara, I'm coming to that. Wait, I know this. It is, however, made clear that while taking the said decision, the said authority shall take note of that the grade pay of the in the cadre of the deputy CEO has to be higher than the grade pay so given to the officers in the grade cadre of the BDO. Next. Mr. A.C. Barbara, the learned senior counsel, further submitted that during the pendency of the instant writ petition, some of the petitioners have already retired.
My respondent petitioner 2, 3, 4, 7,
No, it's
and
okay.
10.
Not this. Some of the petitioners have retired. And some are
On the verge.
on the verge of retirement. এইটো পিছত লিখিব তাৰ আগতে another sub issue duly arises as regards the entitlement of as to from which date the petitioner's hearing would be entitled to the higher grade pay. Taking into account that on 23/2/2021, the BDO, the officers in the cadre of BDO have been granted the revised pay scale a great pay of rupees 12,700. And they have been enjoying since then. The increase in the grade pay of the petitioners or such other officers in the cadre of the deputy CEO would be from the date the revised grade pay was granted to the BDO, that is 23/2/2021. Mr. A.C. Barbara, the learned senior counsel, further submitted that during the pendency of the instant writ petition, some of the petitioners have already retired and they are getting the pension on the basis of the grade pay presently of the present grade pay of rupees 12,700. This court further observes that upon the said decision being taken as regards the enhancement of the grade pay by the authorities as directed herein above, the petitioners herein would be entitled to the arrears. The petitioners herein who are presently working would be entitled to the arrears on account of the enhancement in the grade pay. And the petitioners who have already retired would also be entitled to the grade pay, would also be entitled to and the petitioners who have retired prior to 23/2/2021.
No, my lord. Nobody, none of these petitions are retired prior to 21. This is a civil, this is a.
No, let them verify. Let them verify. If somebody has retired prior to 23/2/2021, he won't get anything.
Nobody.
No, it's okay. The question of enhancement of the grade pay would not arise. However, in respect to those petitioners who have retired after 23/2/2021, would not only be entitled to the area in their salary on account of the higher grade pay, but would also be entitled to recomputation of the pension on the basis of the higher grade pay. With the above, the instant petition stands.
Pension on the respective date of retirement.
That is there, but not from earlier. That is why I said they will do the recomputation. The said exercise be completed within a period of 4 months from the date a certified copy is served upon the chief secretary to the government.
About the, my lord, CEOs who are still young, the promotion aspect may, lordship may leave it to the.
I'm not said anything.
Lordship has already accorded service rule exists. Unless and until service rule is not touched upon, my lord, we cannot do it.
I'm not saying, I'm only concerned with you.
Only the service rule on the basis of which they are getting the benefit. I'm so grateful, my lord.
Timing item 4.
Yes. What is this matter?
Timing item 4.
Oh, Mr. Dhar. That's 1,36,000 you are willing to pay?
My lord, I have got a, I told you.
Things to go work.
It's a, my lord, handwritten instruction from the executive engineer.
Very well. At least we got something. In reference to case number so-and-so, the bill of so-and-so in respect of so-and-so is processed, is in process, and the payment will be made, what do you read, on the first,
No,
second, from, what is that?
I will read from the, as soon as I think, my lord.
As soon as the
As soon as,
Will be made as soon as
As
the
soon as-
first,
fund, my lord, it's fund.
the fund
Fund
is
is secured
from the
from the
authority.
authority.
Fantastic. This was given on 24th of April. Heard Mr. N.K. Kolita, the learned counsel appearing on behalf of the petitioner. Mr. Ardhor appears on behalf of the PWD, as well as Mr. R. Babuzari appearing on behalf of the Finance Department, and Ms. D. Bora appears on behalf of the Health and Family Welfare Department. The claim of the petitioner herein, the instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in not releasing the medical reimbursement bill of an amount of rupees 1,36,708, which have been duly approved by the district level medical reimbursement admissibility board, Kamrup Amingaon. During the course of the hearing, the learned counsel, Mr. Ardhor, submitted that the executive engineer PWDR North Kamrup Territorial Road Division had informed him that there is no dispute as regards the entitlement of the petitioner to the amount of rupees 1,36,708, but however, the payment would be made as soon as the fund is secured from the authority. Which authority?
My lord, authority means he is referring to the government, my lord.
Huh?
From the government, my lord.
Government means which government gives?
PWD, my lord, the department, my lord.
Okay. Taking into account that the matter, that the amount is not disputed, this court, when you were entitled to?
My lord, it was, treatment was of 2018, my lord.
Taking into account that the reimbursement bill of the petitioner, medical reimbursement, was of the year 2018, this court therefore disposes of this instant writ petition with a direction to the whom?
My lord, PWD, my lord, this.
What PWD? Then tomorrow you may say he has not come, you have not made him a party and all. What is this?
I'm giving specific, my lord.
Yes, specific. Or you? Direction to you?
My lord, it is 7 and 9. Chief engineer and my lord, they will settle
With
it.
a direction to the respondent number 7 and 9.
My lord. The person who has given this instruction, my lord.
Yes. To pay the said amount, to disburse the said amount of rupees 1,36,708 within a period of how much?
2 months, my lord.
2 months from the date a certified copy of the instant order is served upon the respondent number 7 and 9 respectively. The respondent in the PWD department, if so necessary, shall take, not necessary, 1,36,000. Yes, good.
The chief engineer.
The instructions so furnished by the learned counsel for the petitioner, a respondent PWD department is kept on record and marked with the letter X. Yes, Mr. Das, you're back.
Yes. In fact, only one instruction was sought for from the central government, Mr. Roy. He was to clarify the RTI part. Basically, we could show that inclusive, it's not an extensive or enumerative, it is rather a very exhaustive and.
Tell me your case. You need a judgment for that. I think you good sense should prevail. Go ahead with the gamusa, no problem. But how are you taking up with the? You know this is wooden cover.
Lordship, here, but since today, one of the time is it's 4:30. My senior, he has left. Just 5 minutes back, he left. Kindly keep the matter on Tuesday,
Due to possible, has the other matters got listed?
Yes, yes.
All the matters.
All the matters are not.
They have seized their materials.
Yes, the last 5 from down. Number with that.
No, it's okay. They have seized it.
Yes, sir.
You have filed, you have also asked for compensation.
No, my lord. Actually, what has happened on the first day, since we were not given an interim, I asked for an coercive action. That unfortunately, that also I didn't get.
Okay. Hello. Heard Mr. D.K. Das, the learned counsel, appearing on behalf of the petitioner, and Ms. D. Nath appears on behalf of the state of Assam. Due to paucity of time, the hearing could not be completed, and as such, let the matter be again listed on Tuesday. Tuesday is
30th.
Tuesday, immediately after the top of the list items. Yes, Mr. Gogoi. Here we don't have the problem with the Advocate General being there. Now tell me, we still have time for half an hour.
Here, otherwise I have got the instruction.
Yes,
Lawsuit
how do you link? It is
Well-
only the question of linking.
Yes.
If you can link this with that, you have a case.
Or if lawsuit allows, I'd like to file one fraud affidavit. I bought a bunch of documents.
What documents?
Lawsuit. But so far as the SLEC is concerned, at that time, when the selection was held in February 2005, it is the state level empowered committee that was prevailing.
I know that.
Yes.
Then
Now, as per that notification of constitution of or say office memorandum of that SLC, it says that there will be a committee where the highest authority of the every department who wants to seek the approval will be a member of that particular committee. In the present case, no SLC approval was sought for by the joint director. Had it been
understood.
Yes.
But how do you connect it?
Yes.
That is the problem. I'm only asking you very well. That is required. But how do you connect it? If you connect it, we have a case.
Yes, in that case,
but that is not your ground.
Yes. Otherwise, in the rules also, the rule prescribes that the appointing authority will be the one who will be delegated with the power for appointment. In the present case, the joint director has issued the appointment letters, but the delegation is not there. That's why, all along we are stating that they have not approached the higher authorities. They will have to first intimate accordingly.
Who is the appointing authority?
Appointing authority will be, if Lordship takes up 1997 rules, the Assam Public Services Direct Recruitment to Class 3 and Class 4 post, rules 1997. Definition says that the appointing authority means the authority to whom the power of appointment is delegated.
Wait, nilagay na phone daw. Today I thought of delivering the judgment in your presence, but that matter took some time.
Yes.
Yes, 97 rules.
115, page 115.
Tell me. Yes.
Definition, 2A. The appointing authority means the authority to whom the power of appointment is delegated. So this delegation of power will have to be from the higher authority. That is either from the director or from the government. And that will come only when the joint director, before conducting the selection process, he will have to move the authority to give the delegation to the power, give the power to appoint, as well as.
So is it your case that you have not delegated the joint director?
Yes, my lord. Because
no, not for that.
Not at all aware, my lord.
No. Is it your case that the joint director had no power at all?
Well, without that delegation, my lord, he cannot. In fact, my lord, I have instruction to place, my lord, written instruction that, my lord, from 1999, my lord, when this SLEC was constituted, till 2006, there was no selection as per our record of grade 4 and grade 3. Specific instruction, my lord. It is only, my lord, when the SIU came into being, thereafter, my lord, the government directed that, my lord, whatever is the backlog, it should be immediately filled up. And in 2006, for the first time from 1999 to 2006, my lord, that process was initiated for filling up certain posts.
But
70
why haven't you taken action against the finance?
Finance, yes, my lord, on the last occasion also the other
Because
side
this is a
argued.
serious thing. If something has
Yes, my
happened,
lord. In fact,
the
it is
finance
serious.
is there.
Because how they were getting the salary,
It couldn't have
even
been
after,
done.
my lord, SIU approval, my lord, all those, my lord. Because there was a direction in the notification for constitution of SIU, my lord, that, my lord, whatever posts are presently available, say from July 2005, it was to be scrutinized.
Then why nothing was
My
so?
lord, that's the scare, my lord. Otherwise, all might be all are involved or not, my lord, we cannot
So
say.
have you
whether
given it to the CBI?
they- No, my lord.
You give it for small matters also to CBI, not, why not this?
That, of course, some observation from your lordship, my lord,
Huh?
make.
Why CBI has not been brought in?
Otherwise, my lord,
Okay, what has happened to your investigation?
my lord, that part, my lord. So, my lord, so far as the records are concerned,
The
that
criminal have you, if you just file an FIR just for the sake of it
my lord.
and thereby debarred, that won't be proper. But
No,
have you
my lord,
taken
some
actually
officers were arrested. Now all are on bail.
all joint directors?
No, not the director. Some LDA, UDS, they were arrested.
See,
My
again,
lord, they are the main
again,
person, my lord, who will issue these appointment letters. Not in this present case, but
Who?
other cases,
who issued the
they, my lord, otherwise, my lord, the appointment letters are in format of similar appointment letters. Even the issue numbers are same. But when we verify the record, we find that, my lord, the appointment letters are issued to X. Now, another Y has come up with the same, my lord, issue number, same format, my lord, but name is different. So that's the issue, my lord.
That is it out there in these two good districts for him?
No, no, not in two districts.
So we are only concerned. The others,
That
I'm
part,
not
my lord, so far
bothered.
as the selection is
Others
concerned.
too, he also know. We are on paragraph 26.
Yes, yes.
So paragraph 26,
No, my lord, that also, my lord, I have gone through again, my lord, para 26 of the Jammu Kashmir case, my lord. Finally, in para 26, the Honorable Supreme Court has spelled out that, my lord, the entire regularization scheme, my lord, if at all the government wants to take, it will have to be within the ambit of para 53 of Umadevi.
absolutely.
Again, my lord, the three conditions will come in, my lord.
I'm not saying, I'm saying that illegal appointment you cannot.
Yes.
Irregular appointment you
Irregular.
can.
Yes.
That is only you can regularize. I'm not saying that you regularize.
But here, my lord,
Here,
again, that
I
10 years
cannot
period will
direct.
come.
No,
10
no.
years, my lord.
No,
till the date of-
Mr. Gogoi, I am not going to direct you to do anything.
Yeah.
I am only giving that this is the parameters by which the government in its own wisdom can think fit.
In fact, my lord, that
I'm not
notification is
going to
already
say.
there.
I am not going to say anything.
No, my lord, pursuant to Umadevi, that notification is there. Whoever is otherwise eligible. A proposal goes, finance will examine, and their persons have been regularized. It's not that nobody has been regularized.
Then why are people filing writ petitions?
My lord, some, my lord, who do not come under that particular and are not aware of the Umadevi strict conditions.
No,
they
no,
used to
that
come.
was Mr. Counsel, paragraph 26 has to be inserted. Then only the state will start believing that illegal cannot be legalized by regulation.
Yes.
This is very regular, important. This paragraph 26 is a very important paragraph.
My lord.
You cannot legalize an illegal appointment. You can only legalize
We can
irregular.
by removing the irregularity.
Irregular, only to that extent.
I understand.
What is being happening out here in all the schools, all illegal appointments.
Right.
But then government is doing. So this paragraph 26 happens to be the main person.
My lord.
If you find that it is illegal, then well, if you find it is irregular, it is absolutely within your wisdom to do or not to do.
Possible. In fact,
I'm not
my
saying
lord,
on that.
I have got
For
the-
that, I'm not worried. I'm saying about the other two cases where he has a good case.
Yes.
There, what do you have to say? There you are not, you are again coming back to that.
No, no.
There
so
you
far
know,
as
this
to
court
my lord-
was supposed to deliver a judgment itself.
Walpara
In fact,
and
your
my lord-
lordship's specific query is that whether there is something to connect. He said no. He said he could not.
Walpara and
Mr.
Dibrugarh. My lord,
Sinha,
let me-
don't expect this court is to cut short of these things and not give him a further one day opportunity.
No, no, I'm not
to
saying that. Your
opportunity.
lordship will give.
Let
him
him
a-
file affidavit if he can link it.
My lord.
Because it is only the question of linking. Now, one is saying that the appointing authority means the authority to whom the power of appointment is delegated. Now, he has to give an affidavit that no power was delegated to the
Yes,
Without that, this court is not going to hear to this argument.
Yes.
What is 2A or 2B?
On
No,
oral
this
submission.
court
of
is
course.
not going to do this.
So, my lord, either on first of my lord June or 6th, if not convenient, my lord, inconvenient.
Sixth will be better, your lordship.
When are you filing your affidavit?
My lord, I can file it by say Tuesday or Wednesday next week.
Next
It's
week
not
is
affidavit.
what? Next week is
Either first or 6th, if not inconvenient. my lord.
first is no. I have fixed the matter on 30th.
Yes, 30th.
The other- other
Yes,
way,
yes, on 30th.
Okay, first kineko avostha.
Your lordship, can it be on 6th? Because if he's filing on Wednesday, then I'll require 2 days of time, your lordship.
On 6th, yes. If not,
If he's filing it on.
yes, yes,
30th
I
or
will file it by Wednesday, madam. At least he will get a time to reply.
Out Mr. R. Sinha, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi appears on behalf of the Health and Family Welfare Department. The learned counsel appearing on behalf of the Health and Family Welfare Department pursuant to the directions passed on last date.
My lord.
Last date when was that? Last date to get here.
18, your lordship, 18th May.
On 18/5/2023. 6 for an accommodation to file an affidavit in terms with the said instructions received
My lord.
by 31st of May.
No.
Then let the matter again be listed on 6th of June 2023.
No.
The petitioner in the meantime shall be at liberty to file a reply if so advised.
Item number 19, fine,
Hmm?
item number 19, Lord.
Yes, what is that?
I am with this.
Where is it?
In this series,
In this case, Lord.
Series.
Series.
You also want to file?
Yes, yes.
Is it?
नाम तो
I'm
क्या
appealing.
file?
Him.
Anything else?
Deeply obliged.
Obliged.